Item number 12, my senior is out of station, so matter may be taken out sometime.
May it please your lordship, with the consent of the other side, my lord, I beg to mention item number 3, my lord. It pertains to bench 2 matter, my lord.
Mr. R.S. Mr. Learned Counsel for the writ petitioner submits that this writ petition pertains to civil bench 2, but the same has been wrongly listed before this bench 2. Registry to verify and list the matter before appropriate bench.
May I please, lordship? Lordship, I beg to mention for unlisted lordship. Because the transfer matter, unlisted lordship today.
Tomorrow.
Tomorrow, lordship. Deeply obliged.
May I please, your lordship? Lordship, I beg to mention for listing on writ petition, lordship, within this month on any day, lordship.
Why?
Lordship, for listing, lordship, for orders.
All right, why within this month?
Lordship, on any day within this month, because this matter pertaining to the dismiss from service, lordship, due to allegation of rape, lordship, without conducting one disciplinary proceeding, lordship.
Next month.
Lordship,
Next month.
date,
Next month.
next
Yes,
month,
second week of August. Yes, next matter, please.
lordship,
Second week of August.
date, lordship.
Second week of August, you put a date. Yes.
Obliged, your lordship.
May it please your lordship, with the consent of the other side, I like to mention item number 5. Lordship, the matter may kindly be passed over for the date.
You are for the
I am for the petitioner.
Learned Counsel for the writ petitioner, with the consent of the opposite party, 6, adjournment of admission hearing of this matter with a request to put this case again after 4 weeks. Since the
Lordship, can it
player
be-
is not opposed, same stands allowed. This case accordingly.
Lordship, after 2 weeks.
4 weeks.
Lordship, can it be after 2 weeks?
Rejected. Next matter, please.
It
Master
pleases your lordship, I am praying for listing of one writ petition, lordship. Can it be on any date in the next week, lordship? It's a long pending matter, lordship, 2016.
Second week of August.
lordship.
consistent.
March.
May I please, lordship, I beg to mention item number 26 of supplementary list, lordship.
Hmm.
Lordship, my senior is out of station as his brother-in-law expired, lordship.
Item number
26, lordship. Perhaps the matter was part heard, lordship, in before Honorable Soumitra Sogia Justice, lordship.
it is submitted at the bar that this matter is parted before a coordinate bench. Bracket, Mr. Justice S. Sekia. Bracket close. In view of the above, registry to verify and list the matter before appropriate bench after 2 weeks.
Deeply obliged, lordship.
Before the appropriate bench after 2 weeks.
Item 23. May I please? But
Yes.
this matter may be allowed to withdraw, my lord.
Mr. H. A. Ahmed,
Yes, I mean.
Learned Counsel for the writ petitioner submit. Why you want to withdraw? Order has been complied with.
Compliant, my lord.
Submits that the order of this court has already been complied with and therefore this contempt case be closed. Taking note of the submission of Mr. Ahmed, this contempt petition stands closed.
Obliged. Item 24.
This case, I am withdrawing on a technical ground, my lord.
Hmm.
I may be allowed to liberty, my lord. Liberty may be granted.
What technical ground?
My lord, authorities subsequently issued another notification, my lord, depriving the petitioner. Petitioner is working as Anganwadi worker, my lord. Mini Anganwadi work.
So you can't withdraw, you file a fresh writ petition then?
Yes, my lord.
Uh,
With the liberty.
Mr.
K. Kolita.
K. Kolita, Learned Counsel for the petitioner submits that during the pendency of this writ petition, the respondent authorities have issued notification dated,
That I have not found, my lord.
issued a further notification affecting the rights and interest of the petitioner. First of all, unless this said notification is put under challenge, the petitioner may not get the relief as prayed for. As
Yes,
such, Mr. Kalita seeks leave of this court to withdraw this writ petition with liberty to file afresh by incorporating the grounds taken in the present petition. First of, the prayer is not opposed by Mr. H. Chakravarti, Learned Government Advocate Assam appearing for the state. In view of the above, this writ petition stands disposed of on withdrawal with liberty as well.
I am so obliged.
For Muttal, item 1 and 2. May it please your lordship. Look, this is the matter where notice has already been issued on 27th of June, my lord.
This is the matter where of the APSC wherein my lord wrong options are provided as correct answers. So my lord, no, respondents have to file their affidavits. It has come up for motion erroneously perhaps, lordship.
You are also there. I mean, at number 2. You will write, Mr. U Pathak, item 1, item 2, Mr. KP Pathak. These are the only difference. Mr. So-and-so learned counsel for the petitioner submits that by the order dated 27/6/2023, notice of motion. This was not issued perhaps.
It was issued. It's there in the middle of the.
It's there towards the end, my lord.
Does.
Page number 5 of the order, my lord. 5th paragraph from the last.
Paragraph
Perfect.
begins with.
Paragraph beginning with since, your lordship. Since it has been projected that.
Page number 5 of the order.
So submits that by order dated 27/6/2023, notice has already been issued in this case. But the respondents are yet to file affidavit. As such, this matter has been wrongly listed for motion today. Ms. P. Sharma.
For respondent number 2, 3, and 4, lordship.
And counsel appearing for respondent numbers 2, 3, and 4 has prayed for some.
2 weeks time.
2 weeks time to file affidavit. In view of the above, let this matter be listed in the appropriate column after 3 weeks. With item 2, the same order I took over, I am at item 1.
Obliged, lordship.
May it please your lordship, the deputy commissioner office has been abolished and then newly designated as district commissioner lordship. I may be allowed to implement him. I may be allowed to for 2 weeks time lordship for implement.
So it is not abolished, it's renamed only. What is the problem?
No, lordship, Lower Assam Commission and Upper Assam Commission division has been abolished lordship. Right order.
Your name, please? Your name?
D. Burman lordship.
Mr. D. Burman, Learned Counsel for the writ petitioner submits that during the pendency of the writ petition, the office of the Lower Assam Commissioner and Upper Assam
Upper Assam
Commissioner
Commission.
have been abolished. And the office of Deputy Commissioner has been renamed as District Commissioner. As such, he be granted 3 weeks time to file appropriate application for improvement of the concerned officials. Since the prayer is not opposed, Sim stands alone. Let this matter be listed after the IA for improvement is brought on record.
Highly obliged lordship.
I can see.
And appears for the writ petitioner on call. You have received instruction?
No, lordship.
Mr. H. Chakravarti, Learned Government Advocate Assam submits that instructions are still awaited and therefore this matter be listed again after 4 weeks. Prayer made by the Learned Government Advocate having been unopposed, comma. No. Not having been opposed. Now you write prayer of the Learned Government Advocate Assam stands allowed. Let the matter be listed accordingly.
Obliged.
Item 7 and 8.
May I please your lordship? Lordship, the last direction was for final disposal. So I'll argue for final disposal. Lordship, 2 writ petition in this series. The first writ petition we have filed. Because even after completion of the departmental proceeding and imposition of penalty, our promotion to the rank of assistant executive engineer was kept under seal cover. Subsequently, during the
How many petitioners?
one petitioner, only one.
One an hour, you are saying hour? One
In fact, mine,
petitioner.
in fact, mine,
Ah.
mine. Then lordship, during the pendency of the first writ petition, that was in 2125. The Water Resources Department produced a notification of the Personnel Department stating that the period of punishment
if it is not over, then the
Which-
promotion,
Which writ petition you want to rely? upon?
lordship may take up 2240, that will cover up both the writ petitions.
Yes. Yeah, what are the facts? Give me the facts.
Lordship. Lordship, petitioner was imposed with a penalty of under Rule 7(2) of the Assam Services Discipline and Appeal Rules. That your lordship will find it page 72. I'll read out the relevant portion, lordship.
Yes.
At the bottom of the last second paragraph, lordship, page 72.
Yes.
Therefore, lordship got, therefore, the governor of Assam is pleased to impose a penalty of withholding of 2 increments with cumulative effect under Rule 7(2) of the Assam Services Discipline and Appeal Rules 1964. Now, the Rule 7(2), lordship, says withholding of increments or promotion.
Some disciplinary service. Rule 7(2) says,
Where, Rule 7 says the following penalties may be for good and sufficient results and has hereinafter provided be imposed on a government servant, namely. Rule 7(2) says withholding of increments or promotion.
or no, it says of promotion.
No, lordship, in some of the books, it is wrongly printed. I am having the copy.
Ah.
It's or, lordship. Now, lordship,
Yes.
there is an office memorandum of the personnel department, page 135, lordship. Page 135, lordship. Relevant portion of lordship will find it page 136, the last para. May I read, lordship?
Yes.
In the case of employee who have been awarded the minor penalty of withholding of increments or withholding of promotion, promotion can be made only after the expiry of the penalty. Now the date. Now we are aggrieved by this, lordship. Now a coordinate bench of this High Court
Yes.
this High Court has precisely dealt with this issue and interpreted it, lordship, that your lordship 1994 1 GLR 427, lordship. I'm having a copy of this. It says, lordship, clause 2 of Rule 7 of the said rules runs as follows: withholding of increments or promotion.
Please wait till the judgment is given.
The last judgment, last flag mark, lordship.
Yes.
The last page, lordship. Para 10, lordship. Therefore, the intention of the rule maker is very clear that the authority cannot impose the punishment of withholding of increments and promotion. Only one punishment can be imposed, namely either withholding of increments or promotion. Now, lordship, I am a recommended candidate since the year 2019. I am the senior most assistant executive engineer. Assistant engineer. That minute your lordship will find at page 101. My name reflects at page 101, serial number 7, Lordship, Debasis Acharya. Then Lordship, page 103, it says that my recommendation has been kept under seal cover at page 103.
Just a minute. Yes.
Page 103 says, Lordship, the last para, on the basis of the position elevation of marks in the ACR and the status of submission of APR at Annexure 1, the selection board decided to recommend 12 officers for promotion to the rank of assistant executive engineer against 13 number of vacancies. As there is a departmental proceeding pending against the Debasis Acharya, the board further decided to keep recommendation in respect of Debasis Acharya under seal cover. Then Lordship, subsequently, the 20 also, my recommendation was kept under seal cover. Then the final gradation list for the year 2022 was prepared, Lordship. Lordship will find it page 126. My name reflects as serial number 1. Now, my prayer is, Lordship, as the departmental proceeding is over and the penalty has been imposed after under Rule 7.2, my promotion cannot be held up. I am eligible since the year 2019. So my promotion should be given effect by opening the seal covers from the year 2019. That is my case, Lordship. And in fact, Lordship, I have given a set of judgment which says that this office memorandum is an executive order that cannot be that cannot overrule a statutory provision frame under.
Please, the judgments where.
Lordship, I have given.
Ready.
The first judgment, Lordship, 1998 8 SSC 469, para 2. It is a full bench judgment, Lordship. Para 2. I'll read the relevant portion at the short point on which this appeal must succeed is a governor tribal so and so. The relevant rule, it is admitted, were framed under the provision of Article 309 of the Constitution. They are statutory rules. Statutory rules cannot be overridden by executive orders or executive practice. Now, the second judgment, 2011 11 SSC 136.
Yes.
Para 10, Lordship.
Yes.
The fifth line, Lordship, it is a well settled that the statutory rules framed under 309 of the Constitution of India can be amended only by a rule or notification duly made under Article 309 and not otherwise. Whatever be the efficacy of the executive orders or circulars or instructions, statutory rules cannot be altered or amended by such executive orders or circulars or instructions, nor can they replace the statutory rules. The rules made under Article 309 of the Constitution of India cannot be tinkered by the administrative instruction or circulars. Now, the next judgment, Lordship, this is a division bench judgment, para 8 and 9, Lordship. It reaffirms the same, Lordship. It is a well settled that statutory rules framed under Article 309 of the Constitution can be amended only by a rule or notification duly made under Article 309, not otherwise. Whatever be the efficacy of the executive orders or circulars or instructions, statutory rules cannot be altered or amended by such executive orders or circulars or instructions, nor can they replace the statute. The rules made under Article 309 of the Constitution of India cannot be tinkered by the administrative instruction or circulars. Now, Lordship, the OM that they have placed by the personnel department is an executive order. So that cannot overrule the statutory rules. That
What
is
is it?
7.
Which rule? Which
Rule
bit?
7.2, Rule 7.2, under which I have been imposed with a penalty.
So how does it overrule Rule 7.2?
Rule 7. Lordship, by Rule 7, it says withholding of increments or promotion. That means either one of the punishment can be imposed upon me, not two. By withholding my promotion, they are imposing two punishment at one time. In fact, if your Lordship again reads this order of penalty, it clearly says that only page 72, the governor is pleased to impose the penalty of withholding of increments with cumulative effect under Rule 7.2, not promotion, my lord. Either one punishment can be imposed upon me, not two, Lord. That is my case, Lordship. So
Why
my
two-
prayer will be,
Why
Lord,
two writ petitions?
two writ petition. First writ petition, because this office memorandum was placed during the pendency of the first writ petition, that we have challenged it. In the first writ petition, we could not challenge because that was not placed. So we have challenged this by way of the second writ petition. That covers both the writ petitions, Lordship. In the first writ petition, we prayed for opening the seal cover and going ahead with our promotion. In the second writ petition, we have challenged the office memorandum by which our promotion has been withheld. Now, in fact, pleadings are complete, Lordship. In the other writ petition, personnel department, office memorandum have showed that statutory rules, it is a statutory rule framed under 309. It cannot be overruled by way of an executive order. The office memorandum is an executive order, Lordship. And in fact, the punishment that has been imposed upon me, that has been given effect by withholding of increments, that your Lordship will find at page 137.
But your client has not challenged the order of penalty.
We have challenged, that is pending.
That is.
In fact, if we do not succeed in that writ petition, then also it will not affect these two writ petitions. Because these two writ petition is based on that two punishment cannot be imposed upon me. Only one punishment can be imposed at a time, that is withholding of increment, not promotion. I am a recommended candidate. I am the senior most assistant engineer.
What is the other case number?
2125. 2125. Huh? No. Other two.
No, where you have challenged the order of penalty.
885 of 2022. 23, Lordship, not 20.
23.
23.
Yes.
Now, Lordship, kindly peruse page 137 for a one. Please. Lordship, my date of imposing penalty was 18/4/2022.
Mm.
18/4/2000. This is a salary slip of 12/5/2022. On the next month of imposition of penalty. There, Lordship, on the third row, your Lordship will find page 137.
Yes.
On the third row, your Lordship will find my increment has already been withheld. On 1/1/2019, it was 43,050. On 1/7/2019, it has been kept withheld. The same. On 25/8/2020, it has been withheld. That means it has already been given effect. Now, my only prayer is, Lordship, my seal cover should be opened and my promotion should be given effect, considering my ACL.
It will pension, sir. Yes.
Regarding the OM challenge, that personnel department will have to say, Lordship, that I will not. But regarding this one, Lordship, his punishment, Lordship. What happened, Lordship? His punishment was imposed on 19/12/22. 2 years means 2 increment have been held up, Lordship. Regarding the promotion, Lordship, the promotion is the consequence effect of that one, Lordship. Promotion is not being held up, but it was the consequence effect of the increment, Lordship. That is why his promotion,
What has increment got to do with promotion?
Lordship.
What has increment got to do with promotion?
No, in increment order, it means in the punishment order, it has been clearly stated that 2 increment will be held up. 1 increment, that is on 19/12/22 is punishment. In normally in Assam government, the increment been given in the month of July. So 23 July, 1 increment, and 24 July, 1 increment. Thereafter, his envelope means seal cover envelope will be open, Lordship.
On what basis?
Lordship,
Where is the rule permitting that?
Lordship,
Where is the rule permitting that? Increment. See, stoppage of increment is a penalty.
Lordship,
So either he succeeds in getting it set aside, in which event he will get the financial benefit,
Lordship,
or he has to suffer the financial. loss.
Lordship, Lordship.
But what has that got to do with promotion? How are you drawing a link?
No, promotion is not been affected, Lordship. Promotion is the consequence effect because of the OM of personnel department, Lordship.
All right. So
Lordship,
therefore you have nothing to say.
Lordship, Lordship.
Who is for the personnel department?
Lordship, if you go by the office memorandum that is at page 135,
Hmm.
the relevant portion is at 136.
Hmm. Hmm.
He may be promoted in his turn if the penalty is that of a censure or recovery of pecuniary loss caused to the government by negligence or breach of order. In the case of an employee who have been awarded the minor penalty of withholding of increments or withholding of promotion, promotion can be made only after the expiry of the penalty. So in his case, Lordship, the withholding of increment is there, Lordship, that is for 2 years.
So what has that got to do?
Only after expiry of that penalty. That is the office memorandum.
What is the nexus between the two? There is a penalty of withholding of promotion.
Lordship.
If that penalty is imposed, one can understand. But withholding of increment is a completely different matter.
Lordship. But that is the office memorandum. It was.
Does it not defy logic? When withholding of promotion is a separate penalty,
Lordship.
unless that penalty is imposed, how can penalty?
May I pray, Lordship, let this matter be fixed day after tomorrow, Lordship, in the, as because, Lordship, let me get the,
No, we have adjourned it a number of times. It causes.
as a
inconvenience.
pardon matter, Lordship, I have,
No, another day, another kind of.
that is true, Lordship, I'm,
We also need some mental preparation before hearing and
Lordship, that is true, Lordship.
just after hearing, focusing, suddenly it is adjourned. Some other matters come.
That is why I am praying that let it be kept at pardon. Only this much of Lordship, otherwise I am also in total dark, Lordship, why this is, let me clarify this point, only this point.
Legal issue. That
Lordship.
issue was raised last 2-3 occasions. Probably you were not there. as
Lordship,
counsel.
that is the, sometimes that problem is there, Lordship, but I'll do what was that. Only
What
that much,
instruction you want?
only that, only little accommodation, let me go through it, Lordship. If it is not in accordance with the law, Lordship, then I will, let me
You
go
make an
through it.
attempt now, by the time. I
Yes,
get
sir,
to
Gopi is
the-
here, Lordship, but apart from that, Lordship,
Go through it. Let me see
only legal accommodation tomorrow itself, Lordship,
What Mr. Day has to say, let me see.
Lordship.
Sorry?
In the first case, the WPC I am not appearing.
You are not appearing.
All right. Second case, I am the implemented respondent, my lord. On merit, I have no objection, my lord. I am only aggrieved by the interim order, my lord. If one post is kept vacant, I have no objection. Other may be-
In fact, that's why your lordship has placed this case for final disposal because your lordship has stayed the entire promotion process. So I don't think lordship, because I have placed the judgment, lordship, full bench, division bench, as well as the coordinate bench. So lordship will dispose of the matter today itself. In fact, the water resources department has filed an affidavit that there is a
Please
thought.
take your seat. Take your seat. Mr. Sharma, this was fixed today by a specific order.
I have seen, Lord. That is why I have not, otherwise I would have prayed initially, Lordship. I have not prayed, Lordship. Let it be kept only little accommodation. If your Lordships,
You want half an hour? I can give. you.
Lordship,
Not more than that.
Lordship,
We'll call
Lordship,
up after half an hour.
Lordship.
Yes.
May it be heard. Your lordship, petitioners, your lordships are aggrieved by the promotion order of the respondents who were admittedly juniors. Lordship. Now, during pendency of this writ petition after issuance of notice and service also, they have initiated steps to promote those juniors, lordship, to the next higher post of appears junior grade, that is from inspector to deputy SP, lordship. That is why I filed this IL, lordship, because parallel proceeding is not permitted, lordship, in view of Akadda Sali. So that is why my plea is that the process may go ahead, but not to finalize the process. Huh? And in fact, lordship, this has been issued in violation of the rule 39, the promotion of the junior without confirmation of service. The rule says first appointment, then minimum 6 years of service, then confirmation, then promotion. But in respect of the respondent, lordship, they have been appointed in 2010. Thereafter, without confirmation, after 6 years, they have been promoted to the post of inspectors.
But there are two categories. We are Inspector UB and they are Inspector AB. Our substantive post we are directly recruited both the AB and UB in 2008, the petitioners in 2010, the respondents. From the Gazetteer list also it is clearly reflects that without confirmation, their service has been promoted.
Rule 29 of which rules?
Rule 39, Lord. So I have quoted in the writ petitions in paragraph. In paragraph, Lordship 8.
Your
page
lordship is
43.
taking up the IA or the,
IA.
In page 43, paragraph 8, Lordship, I have quoted. May I read, Lordship, from the writ petitions?
Yes.
Page 43, paragraph 8. May I read, Lordship? Go, Lordship. I am reading from the writ petitions itself. Paragraph 8, that it is stated that 43. Rule 39 of Assam Police Manual Part 3 prescribe the procedures for promotion to the rank of inspector from the rank of directly recruited sub-inspector. Here we all are petitioners as well as the respondents are directly recruited. For any reference
Your
criteria,
clients are all Inspector UB
UB,
and the private respondents are Inspectors AB.
AV.
Your
Amber,
case is that they are junior to you,
yes, Lordship.
but even before their confirmation,
Yes,
they were promoted to
inspector from the post of sub-inspector to inspector. Now they have taken again step during pendency for promotion to next higher post, that is deputy SPA, APS junior grade, Lordship. I have annexed in the IA, Lordship. The rule 39,
And what is the main controversy in the writ petition? What is the prayer in the writ petition?
prayer is, Lordship, because since, Lordship, it is
No, not because. What is the prayer? You are giving me the reason for the prayer. I want to know what is the prayer.
that they have been promoted in view of OM, Lordship without following the rules that OM Lordship will find at page 106. And this also exclude the service of the UB. Lordship kindly come to page 106
Mr.
annex 8.
Dekka, you are just not answering the question of the court. You are just saying things that you have prepared in your office. You are going on saying it. I don't want to know what is your preparation. I want to know answers to the question. I am saying in the original writ petition,
Lordship.
what is your grievance?
My grievance is that, Lordship, since the respondents are junior and they have been promoted, that is why I have challenged their promotional order itself, Lordship.
But you have also been promoted.
But we have been promoted subsequent to the respondent, Lordship, because after confirmation, we have been promoted. But in respect of the respondent, before confirmation, they have been promoted. That is my grievance.
Therefore, your writ petition appears to be misconceived. You are claiming seniority. Where is the question of challenging the order of promotion?
Not,
You are claiming seniority over the private respondents.
if you, Lordship, kindly come to page 53, the prayer portion, Lordship.
Yes.
The promotion order says that we are setting aside for this promotion order. There are, Lordship, 5, 6 numbers of promotion order in respect of the respondents.
You can't challenge the promotion order. If your grievance is that you are senior to them, how can you challenge the promotion order? You can ask for declaring your seniority over them.
Even, Lordship, second president, we are also seeking at par, Lordship, because since they have been promoted. This, if you go over the
So,
second,
Mr. Dekka, I am putting it to you once again. I am requesting you to please listen to the query.
Lord.
Otherwise, there will be unhappy ending. Please listen to the query.
Lord.
Your case is that the private respondents were promoted from SI
Yes.
arm branch to inspector arm branch before your clients were promoted.
Yes,
Although they were junior to you and their services were yet to be confirmed. So you are challenging their order of promotion on the ground that those were issued irregularly. But basically what you want is that you want your client's seniority to be restored over the private respondents. Is that correct?
True, Lord.
That is number one. Now, any gradation list of inspector has been published? Gradation list,
Yes, yes. It is, I have annexed, Lordship.
where is it?
90, from page 97 onwards.
Page 97
Not
onwards.
only, it is from, it starts from page 92, page 92, annexer 7,
Achha, this gradation list is under challenge.
this. The name of the respondent, Lordship,
The gradation list is under challenge.
that is, Lordship, not put to challenge. Corner, maybe. No, gradation is not put to challenge, Lordship.
Then if the gradation is not challenged, how will you get relief here? Assuming that they were not confirmed. The department can grant ex post facto confirmation, the matter is that. Your basic claim is of seniority.
Seniority, Lordship, as well as promotion. Lordship.
Huh?
Seniority as well as promotion also, Lordship, because the
But
my,
seniority, you have not challenged the gradation list. The only document, legitimate document of seniority in a particular cadre is the gradation list.
gradation, Lordship.
You have not challenged that. And you are agreed with the seniority. What to do, Mr. Deca? These are,
Lordship,
see, these
let
are
them-
matters which are very technical.
Lordship, then let me have some time, so I will file an additional affidavit. Lordship.
Time you take, but you will challenge the gradation list by an additional affidavit. Is it permissible?
Yeah, main, yeah.
Huh?
Actually, I have the main or first, this one.
I can't say, I'm not here to give legal advice. But if we go deep into the matter, we'll follow the prescription of law.
Lord,
What you are asking for is that your client's seniority should be restored. Because their promotions were irregular. You may probably rely on the law laid down in Rafiquddin's case and some other decision. But you have not challenged the gradation list. That means you have accepted their seniority.
no.
Oh,
In
what
fact,
no?
Lordship, we have highly representation also highlighting all these facts, Lordship.
He has either understood and is pretending not to understood, or it's a terrible matter. Which of the two is correct, I don't know, but Mr. Deca, unless you come up with clarity on this, courts cannot pass orders merely for the asking.
Let me have some time to also
How
think
much
about
time
this
you
matter.
want?
That's after.
Huh?
Next week, Lordship.
Next
Next week,
week.
any Lordship.
So what do you have to say on his prayer, though technically there are minutes?
Lordship, regarding the IA, your lordship made a query that as because in the rule of 66, this 7 years, completion of 7 years is there, why it is put 5 years? So I have contacted with the department lordship and I have found that there is a gazette notification of 1975 whereby it was reduced to 5 years. That notification is here. So their main contention is that in the IA, that in spite of they have not completed 7 years, they are again going to be promoted.
Where is the notification? Do you have
Yes,
it?
lordship, I have got that
Can
notification.
you show it to him? Mr.
Yes,
Deca?
lordship, most.
My copy, dear.
Initially in
Deca,
66,
You better take cognizance of things that have been said.
It is 7 years, Lordship.
no,
No, in sub rule 2 of rule 7,
figure
the
7,
7 as amended
applicable
in between the what's less than.
less than, and
And
years of service in the 5th line has to
Fifth
be
line.
substituted by figure 5.
We have 5.
So initially in 1966 rule, it was 8 years. In 1968, by way of a notification, it was reduced to 7 years. Then in 75, it was again reduced to 5 years, which is not reflected in the book.
Mr. Deca, it is not our job to give legal advice, but you better withdraw all these proceedings and file a fresh petition. Otherwise, what will happen? You don't have the pleadings. You go for an amendment, it will take 6 months to get an amended writ petition on record. What do you want to do? You decide.
Which of next week,
Your technically, your petitions are totally serious shortcomings. You have not hit the nail on the head. You are not targeting the main issue. Your instructions are not complete and correct. Notwithstanding that, if you are asking for interim order, then how will the court deal with it? We cannot be ignorant about these things.
next week, Lakshmi.
Why don't you think about it and come back after 1 hour? We'll give you the liberty to file fresh writ petition. You think about it, come back in 1 hour. If you still want time, we'll give you time.
Lodge, after half an hour, Lodge.
All right,
Lodge.
but if you want time,
Yes, yes.
we'll give you time, no problem. But the
Technically,
fact of the matter is that you are up against a wall.
And Lordship, so far I have gone through the books, Lordship. So far my knowledge goes AB and UB to different streams. So whether they can challenge their
No, they are-
commission.
they are-
Lordship, but even then, Lordship, I am not.
Same pay scale.
You rethink your strategy, what you want to do, because you are dealing with the interest of large number of people.
Correct.
There will be a problem in future. Think about it. Don't experiment in these matters, because when the matter will be heard, judgment delivered, you cannot do anything after that.
May I please, Lordship? Lordship, from the office note, it is in that private respondent is not served, Lordship. So I may be allowed to give justice service, Lordship.
But you have to take fresh steps also.
Lordship.
Correct. Heard Mr. A. Islam, learned counsel for the writ petitioner. Also heard Mr. J. Handik, learned traveling counsel, Revenue Department, Assam, appearing on behalf of respondent number.
Respondent 5.
Respondent number 5. Mr. H. Sharma, learned additional senior government advocate, Assam, is present on behalf of respondent numbers 1 to 4. No, revenue disaster is 1. Why do you say 5?
No,
I am
for one,
Handik
one,
for
two,
one.
and three. Finally.
H. Sharma for 2, 3, and 4. Perused office note, which goes to show that service of notice upon respondent number 5 is not yet complete. In view of the above and on the request of Mr. Islam, the petitioner is granted leave to take fresh steps for service of notice upon respondent number 5 by registered post with AD. Steps within a week from today. In addition to the above, on the prayer of Mr. Islam, the petitioner is also permitted to make dusty service of notice upon the respondent number 5, to be routed to the registry of this court and thereafter file appropriate affidavit. Let the matter be listed accordingly.
One thing, Lordship, in reply, Lordship, page 37, Lordship, my learned brother filed his reply. In his reply, Lordship, he has mentioned a office communication, Lordship, but that is not made annexure. So, Lordship, may kindly direct to.
No, if it is not made annexure, they will not be able to rely on it. How can it be done? When the matter is heard, then we'll see. Call for the registry.
Oh.
May I please?
Yes.
Herein, my lord. Herein, my lord, petitioners has been sought by way of forced retrenchment by the department, my lord. Condition is that if you are not accepted the IVRS, then you are bound to force for retrenchment. Accordingly, my lord, notices were issued, my lord. Lordship, kindly look into page 28, my lord. My lord.
May I please, my lord.
This is the case of retrenchment. What happens? The three writ petitioners before your lordship, they were working in the Central Inland Water Transport Corporation Limited, your lordship, a Government of India undertaking. It was a loss-making public enterprise, your lordship. And on 31/8/2016, Union Cabinet taken a decision, your lordship, for dissolution of the company, your lordship. For dissolution of the company,
What was the date? Decision?
31/8/2016, your lordship. Government of India. And thereafter, my lord, the respondent corporation introduced a improved voluntary retirement scheme, your lordship. Although it says voluntary retirement scheme, but they are forcing the employees to accept the voluntary retirement scheme. Improved voluntary retirement scheme. And under the old pay scale, your lordship, that was offered to the employees. Maximum employees have accepted it, but five employees of the corporation, they did not accept. Out of these 5 employees, 3 are before your lordship, and one of the employee approached the Honorable Kolkata High Court. Now, this Honorable Court, at the initial stage, protected us not to take any prejudicial action against the writ petitioners by an interim order. And their interim order subsequently, until further order, continued after further order. During the while this interim order is in force, they have issued the retrenchment notice since we have not opted for voluntary retirement scheme. Since they have got, my lord, remained at 10 to 12 years of service. Earlier, what happened? Rajabagan Dockyard of the same company was dissolved. And then the manpower, assets, liabilities, everything were shifted to my lord, Garden Rich and Garden Rich builders and engineers. Another Government of India undertaking, along with the manpower. Assets, liabilities, everything along with the manpower. So one of the contention of this writ petitioner, that since Kolkata Port Trust, you are transferring the movable, immovable properties, everything to the Kolkata Port Trust. So you could have arranged the transfer of the manpower, as you have done earlier in the case of Rajabagan Dockyard. It was shifted in the another company, along with the manpower, movable, immovable properties were shifted. That was one of the ground, my lord. Now, during pendency of this writ petition, they have passed the retrenchment order, your lordship. They have passed the retrenchment order. Since we have not opted for improved voluntary retirement scheme, your lordship.
Yes, because
1
you
month,
had no option in this matter.
my lord.
You had no option. Either you take VRS or go on retrenchment and fight it out in the court.
My lord, there is an lordship. This court on 19/5/2023 made some queries to the respondents, your lordship, and they have filed an affidavit. That they say, and now, my lord, during pendency, when the interim order, when we are protected by the interim order, they have issued the retrenchment order. That is also in violation of Section 25F of the Industrial Dispute Act.
No, Mr. Chanda, you see, forget which order, which court has passed which order, just forget it for the minute. The company went under, it was dissolved, correct? If it was a loss-making corporation, then it was a permissible mode. If it is wounded up, then normally the employees will be retrenched. But instead of doing it, the corporation came up with some solution in the form of a VRS. That before it goes on liquidation, you go on retirement voluntarily by accepting these benefits. This was an offer made in lieu of pushing the employees into retrenchment, correct? If the offer if the terms and conditions of VRS was somewhere lacking on the touchstone of Article 14, the matter is different. Otherwise, the employees cannot say, no, why VRS? You take this decision, transfer the property there, put us in service here. If you don't do it, we'll go to the court. Very difficult. These are not matters within the ambit of the court. The courts will only see.
After what your lordship is saying, considering this aspect from 19/5/2023, an order was passed.
19/5/2000.
2023, your lordship. Considering exactly considering this aspect of the matter.
Yes, what does it say?
And thereafter, they have filed an affidavit. And we have also filed a counter affidavit. Our counter affidavit, unfortunately, not placed on the record.
I don't know, this litigation appears to be completely unwarranted, unnecessarily. Now, if the court doesn't give any relief, in the lifetime of your clients, they are not going to get anything. Retrenchment order has to be challenged, then we.
No, my lord, we have challenged it by way of an amendment. And pursuant to this order, they have filed an affidavit saying that we have already been retrenched, and that order of retrenchment order 14/10/2016 have been challenged in this proceeding, your lordship, by way of amendment.
We'll hear it in due course, what to do.
My lord,
There is nothing in this matter.
date may be fixed, my lord. We have filed an affidavit, a supplementary affidavit that has not come on record. Now I have checked, my lord. Let this affidavit may also come on.
Clients are not willing to accept IVRS.
Now, my lord, as your lordship, now under the compelling circumstances.
No, Mr. Chandra, there is nothing in your writ petition, nothing. Whenever you do. But at the end of the day, the
But my
kind
lord,
of challenge you are making, that is not
my
permissible.
lord, this retrenchment
This
order-
is like, we don't want this, we want this. The
That
employees
is there.
can't get into
That is
that.
there. I am not disputing that. I am not
Employees
disputing.
can't do. This is
I'm not-
interesting.
I am not disputing that. I am not disputing that. Now, my lord, but while the interim order was under force, they have issued the retrenchment order, and that too also in violation of the section 25A of the Industrial Dispute Act 1947. And we have filed an affidavit, supplementary affidavit.
Are your clients willing to even now accept the IVRS?
My lord, they will have to, my lord. There is no alternative. I have,
This is nothing, just
yes,
7 years of time has been wasted.
my lord. Yes.
I don't know on what advice this was filed, but then, sorry to say this. How
is
can the
It is
these
there. I am not
employees can
disputing.
come and say that
I am,
I don't want this.
because
do
at that point of time, they were under the impression since Rajabagan dockyard, manpower was transferred. My lord, manpower was transferred to the another company. So they will be getting,
So can
that-
the employees put a condition, 5 employees that you
Because-
change the transfer the manpower,
and
get us absorbed there? How
the-
can they do it?
my lord, that was since government of India has taken a decision.
Anyway,
My,
so if they accept it, because otherwise we'll also have to look into how you could
My-
have retrenched them.
my,
It can be a question of contempt.
As per our affidavit, Lordship, they are not, at this stage, Lordship, they are not eligible for improved voluntary retirement scheme. And also they are entitled only the compensation under section 25 of Industrial Disputes Act.
So what is that? What is the-
That is the Lordship, 15 days average pay for every completed year of continuous service or any part year of in excess of 6 months. 6 months.
That amount will be far less than the IVRs.
Lordship. But the
Was there any interim order?
Lordship.
Any
Yes, my
interim- What is the interim order?
Lordship.
Lordship will find interim order. Wait. Initial interim order was granted, my lord. Page 45. 6/10/2016, and which was further continued on 21/11/2016. 6/10/2016. Annexure 15, page 45. my lord.
So this retrenchment is in violation of the interim order of.
My lord, retrenchment order, my lord, interim order passed ex parte, my lord. Ex parte order was
So it
passed.
is not required to be complied with.
My lord, then this, my lord, order has not communicated to the company, my lord, CIWDC.
In any case, the
if
order
it-
is,
my lord-
order will be invalid.
My lord.
Order
My
will
lord,
be
we have already returned the 5 employees, my lord. After that, my lord, this interim order has been communicated to us, my lord.
No, 2/11.
That's why, my lord, petition has been amended. That issue already, my lord, closed.
How it is closed?
My lord, I have filed an IA, my lord, in this regard. It is IA number 112. 17.
14/10/16.
Let us see, I number 1.
6/10 interim order was granted and retrenchment order have been passed
14.
on 14/10. 14/10
My lord, retrenchment order
was passed on 14/10.
14 day, but they have not communicated the, my lord, order.
So therefore, the order is invalid.
No, I am not saying that this order is not invalid. This order is passed ex parte. We have not communicated, my lord.
Correct.
We have returns them, my lord. After returns, seeing that, my lord, they have communicated us, my lord.
So
They have already returns, my lord.
you pay them the IVRS scheme.
No, my lord, now the company is a position to for, my lord, advanced test for closure, my lord. Nothing has been, the company has practically, my lord, in close, my lord. So central government, if central government, my lord, have taken a policy, my lord, have taken a decision, then otherwise, my lord, the company has no way, my lord.
Right, what is this was a completely misadventure. I don't know. How could they have filed this? They have shot on their foot. Heard Mr. M. Chandal, counsel for the petitioner, who submits that additional affidavit,
Supplementary affidavit
supplementary affidavit filed on behalf of the writ petitioners.
on
On
27/2000.
27
of this month, 27/2020.
27
20/07/2020.
2023 is not tagged with the record of this case. Miss R. Devi, Lanet CG, and Mr. A. Kanikar, Lanet,
I am for 2 and 3, my lord, CIWTC.
and CGC for respond number 1, and Mr. A. Kanikar for Lanet Council for respond numbers 2 and 3 are present. Be that as it may, since the supplementary affidavit is not on record, register to list this case again after 3 weeks by tagging the supplementary affidavit with the record of this case. You have to file any rejoinder against that?
No, I think, my lord.
Rejoinder, if any, by the respondents, be brought on record in the meantime. But you obtain specific instruction.
No, my lord, now ball is in the central government, my lord, will decide, my lord.
What is your stand?
This is our stand, Lordship, that voluntary retirement scheme is not, at this stage, they cannot give Lordship. And only the compensation under Industrial Disputes Act, section 25, they are.
What has happened in the Calcutta High Court?
I think, my lord, so far earlier instruction, it was pending. And so far, my lord, even this retrenchment order, it is total in violation of section C of the 25 Act, my lord. That cannot be, because compensation at that point of time, it was not given. Now we are in 2023. And this precondition is to give the notice and to the appropriate government and payment of
compensation, your lordship. That has not been done.
We'll hear it.
And apart from that, my lord, while this interim order was on 4th and it was further continued, my lord, on 21/11/2000. Thereafter, they have issued this retrenchment order.
But it's not your case that there is a contempt of court. It's not your case.
No, because my lord, in violation of that order, they have passed this.
No,
act.
whatever the because, it is not your case that the court's order has been deliberately violated.
That point we have taken in the writ petition. In the affidavit file. Obliged. Obliged.
Lordship, matter take out next week, Lordship. Next week, Lordship.
On the prayer of learned counsel for the applicant may be the consent of the opposite party. These matters has adjourned for 10 days.
Obliged.
For hearing until 11.
No, call for these matters. 1 minute.
Parking matters 7 and 8.
Lordship, I am praying for some time as because Lordship, let me get some instructions. Thereafter, Lordship may dispose of this matter.
Heard so and so learned counsel for the petitioner on the request of Mr. R.M. Das Namu, standing counsel, WR Department, Assam, and Mr. K. Learned counsel for the private respondents are also present. However, when the matter was heard in part, Mr. H. Sharma, learned additional senior government advocate Assam, has prayed for 2 days' time to obtain updated instruction.
Next Monday or Tuesday.
Prayer made by Mr. Sharma. This matter is directed to be posted again on Tuesday, 1st August 2023.
Lordship, if possible, Lordship may fix it on 8, Lordship. Because I'm going out for my wife's treatment.
8th of August.
8th of August. Lordship.
As fixed parted matter. Both these matters. Huh?
That's all.
Lordship, we have filed one interim application for vacating the order, Lordship, which your
It cannot
Lordship.
be done now. The matter is, the parties are asking, your friend is asking for time.
Lordship,
It will not be vacated.
if I argue Lordship, I have to argue it from my own Lordship without there being any. That is why I am praying for some
Lordship,
time.
since the flood is going on, Lordship, and the office is not able to give the promotion.
Put it day after tomorrow. Mr. Sharma, if you can come prepared, you come prepared. We can't accommodate everything. Day after tomorrow.
Lordship, deeply.
Yes, Teacher Lordship. I'm praying for short adjournment, Milord, because in this matter, Milord, I need some instruction to be obtained from respondent, Milord, respondent number 9, Milord, regarding criminal case, Milord. Lordship, unfortunately, on 22nd, his father died, Milord. So,
Whose father died?
respondent number 9, Milord. Since one criminal case was pending for the justice of Karbi Anglong, Milord. Lordship may allow me 10 days at least, Milord.
Yes, Mr. Patel.
My lord, 2015 matter.
Don't sing like record players. You either oppose it and I will record it and go ahead with the hearing or agree to it. Don't say anything.
Fix a short date.
Lordship.
2 weeks. Mr. J. Patwari, and counsel is present on the other petition. Mr. M. Mohanty and counsel appearing for the respondent numbers 8, 9, and 10 has sought adjournment in this case for 2 weeks on the ground that due to a sudden bereavement suffered by his client and necessary instructions for conducting the hearing of this matter could not be obtained. Although Mr. Patwari has expressed urgency in the matter, yet in view of the grounds stated by learned counsel for respondent numbers 8, 9, and 10, the prayer for adjournment is allowed. Register to list the matter again after 2 weeks for final hearing.
Item 12.
Next is the Lordship. My Lord, I pray for small accommodation, Lordship. I need some research in that matter, Lordship. More time, Lordship. Because some new
Mr. K. Majumdar, learned counsel for the petitioner made with the consent of other side, hearing of these matters stands adjourned for 3 weeks. Yes, next. matter.
Item 13 to 15.
Your Lordship, we are being led by senior counsel, Mr. Das. He's stuck in a matter in item, in court number 1.
So
Kindly let the matter be passed over for the day.
we'll adjourn it for 4 weeks.
Okay.
Yes, but because my lord last several occasions it took time. All right, my lord, they have difficulties.
What are these matters?
My lord, they are seeking appointment, my lord, without selection.
My lord, I am in item number 15, my lord. We are, my lord, a master role workers, my lord, and our limited prayer is, my lord, to kindly consider our matter, my lord, by the department, my lord, that we are working between this 5 years period, my lord.
But
We
these
are
are tagged
appoint-
up matters.
My
These are
lord.
tagged matters.
Yes, ma'am, item 15, I am appearing.
All are similar matter. 3 matters.
So if one case, 2 cases are adjourned, then yours will also be adjourned.
I am appearing for the respondents, my lord.
Can it be little earlier, my lord, instead of 4 weeks, my lord?
No. Mr. Deka, today, everybody has forgotten that there is something called convenience of the judge also.
Yes, my lord.
So it is, a time has come for the judges to remind the bar. You are in which case, item?
Item 3700, 13,
Item 13 only.
13.
When these writ petitions were called up for hearing before this court, learned counsel for the petitioner in item 13 has paid for adjournment on the ground that the arguing counsel is not available today. Next one. Mr. B. Goswami, learned additional review is present on behalf of the department. and
My other departments except finance, my lord, for all.
The department, along with Mr. P. Nayak, London Standing Council Finance Department, Assam. However, since a prayer for adjournment has been made by the petitioner's counsel, this court is left with no option but to defer the hearing of these matters. First of Mr. R. N. Decker, Learned Counsel for the petition. Read petitioner in item.
Item number 15, delegation number is.
Why don't you all do the hearing of these cases? We have spent sufficient years in the bar. Every day, senior is on leg, senior is on leg. So what the senior is on leg?
My prayer is not this, my lord. This is my prayer made by him.
Then you argue when we'll pass an order. That's all.
My lord.
That you agree amongst yourself. You agree amongst yourself. Don't come with this senior is on leg. We are not interested. If there is a prayer for adjournment at your cost, we'll adjourn it. Otherwise, these are matters you should have sorted out amongst yourself.
Let
Huh?
the matter.
Huh?
Our matter may be heard, my lord, if lordships wanted me.
That is not possible. So is present on behalf of petitioner in item
15, my lord.
15. In view of the request made at the bar, hearing of these matters can adjourn for 3 weeks. Please sort out these things before coming to the court. Before coming to the court, you sort it out. If it is a tag matter, then either all of you argue or you don't argue. As simple as that. That's how the system operates. So many times the hearings are being adjourned, senior is on legs. There are 4 or 5 seniors.
Yes.
They will always be on legs in some court or other. Nobody is willing to argue matters.
This time, lordship may hear the matter. Next date fixed, my lord.
Who knows? They'll again come up with a prayer for adjournment. Somebody will ask for adjournment. This is how the adjournment culture is just going on and on. If we do not do it, then order is adverse. There will be the ground taken in the appeal. And then the matter is again remanded back unnecessarily. Court's time is wasted.
Absolutely, this is a petition, man. These 3 cases, man, absolutely vague and baseless
That
application.
is probably.
That is
one of the
why.
reasons. Yes.
And in one of the cases, your lordship also imposed cost, my lord. Obliged.
My lord, in this case, my lord, in the beginning, my lord, both the petitioner hearing, my lord, during the pendency has already been declared on attending superannuation, my lord. Both the respondent number, petitioner, my lord, 1 and 2. And so far the private respondent is concerned, my lord. Out of 3 private respondents, 4, 5 and 6, my lord. 4 and 5 has also been returned, my lord. Has also been returned, my lord. Now, as per my instruction, 3 vacancies are there, my lord, because of clear vacancy in the would be promoted post, my lord, from the feeder cadre. So, my lord, my humble submit, my case in this case, in this matter, in a nutshell is this, my lord. So we have challenged that the private respondent number 4, 5 and 6, they have been recommended by the APSC against in the PWD roads department, my lord. But in oblivious of all this recommendation, they have been, my lord, absorbed in the, my lord, the animal husbandry and veterinary department. Now, the department has filed an affidavit, my lord, recent affidavit, my lord. I filed reply there to also, my lord. They said they have been working there, so have been absorbed. So, my lord, law is clear, my lord. When the APSC recommended in order of merit, this person should recommend in this department, either you should accept it in toto, or you reject it altogether, my lord. But when you accepted the recommendation, my lord, in my case, I have been placed in the department, but in their case, my lord, in oblivious of that recommendation, my lord, you have placed them in the department in which they are not recommended, and thereby, my lord, my seniority in the post has been, my lord, be downgraded, my lord. Petitioner's seniority in the post has been downgraded, my lord. Now, if your lordship kindly look into this, my lord, the gradation list that my lord will find, my lord, at page 24 and 25, my lord. My petitioner number 1 position in the merit list was 5 and 6. In the list, my lord, in the my lord, in the recommendation made by the APSC, my lord, it is the recommendation of the APSC, my lord. 5 and 6, my lord. At page number 24 and 25, your lordship kindly have it.
24
and 25. 5 and 6, my lord. 5 is Munindo Taka, petitioner number 1, and 6 is the Pulak Borguhan, petitioner number 2. And lordship will say,
You have filed affidavit.
You have already filed the affidavit, my lord.
They have not denied all this.
Will you please take your seat for a
My
minute? Please take your seat.
My
So
lord,
the 2 petitioners
yes.
and the respondent numbers 4, 5 and 6, they are all serving in the veterinary department, correct?
My lord.
4, 5 and 6 have been shown to be senior to the 2 petitioners. Can you give me the date of their appointment in the veterinary department? When were the petitioners 1 and 2 appointed? Vacha, you are not aware. Now you
No,
are
my lord,
prepared.
I am not aware of the appointment, date of appointment, my lord. I am not aware of the date.
Since it is a seniority dispute, we'll accept his plea and allow the repetition. That's all. That is the only thing that is to be decided here. Who joined service when? Whoever came earlier will be senior. Or if it is the same merit list, then as per merit list. That's the law. We'll dictate the order in 5-7 minutes, but say that no answer could be given by the Learned Departmental Council. That's the only issue. Yes. When were the
One date
petitioners?
is there, my lord, 4th of April 1990, my lord. Annexure B asil niki mane?
When were the petitioners
Page
appointed?
106, my lord.
Mr. Ghosh, when were the petitioners appointed?
My lord, I have stated. Head of the-
My lord, that order is,
When were the petitioners 1 and 2 appointed? I am asking you
that's
when.
a date of regularization, my lord. Only the date of regularization is there, my lord, at
When
page
were
number
they appointed?
106, my lord.
When were they appointed? Let the director come personally. I'm not
My
getting
lord,
answers.
2 days time may be allowed, my
No,
lord. I
no,
will take
let
the
Director come.
instruction, my lord. 2 days time may be allowed, my lord. I will take the instruction about
We'll
this,
give
my lord.
personal appearance of the director on the ground that the department council could not.
My lord, the date of appointment is not there, my lord. The date of their is regularization
Where
is
are the
there, my
records?
lord.
Where are
My
the
one
records?
is my lord 23-10-90.
Sorry,
23-10-90, 1990. Who? Both the petitioner one is
Petitioners were, my lord.
23,
10-1990, my lord. Date of appointment, that's what petition.
yes. And what about private respondents, 4, 5? and
Now,
6?
my lord, private respondents as per this petition list.
My
One
lord,
is-
kindly come to page number 106 of my affidavit, my lord.
Why don't you tell me the date? We'll see it later on.
Yes, my lord, the date of appointment is not with me. The date of regularization is there, my lord.
When,
on
what
it.
is the date of regularization?
That is the order is of 4th of April 1990, my lord. And the date of the letters were issued on 23/3/1990 of all the 3 private respondents for regularization, my lord.
Regularization 23, 3,
10,
1990, my lord. It is annexed in my affidavit, my lord.
which page?
Page number 106, my lord. Annexure B, my lord.
Your affidavit means affidavit by?
My lord,
Affidavit by respond number?
no, the director, my lord, respondent 1 and 2, my lord.
There is no affidavit by 1 and 2.
My lord, affidavit in additional affidavit in opposition file, my lord, on the last occasion. That is on 2/5/23, my lord. This is the second copy, actually, my lord, of the court.
You are
Here
referring
it
to
is.
which paragraph?
Page number 106, running page 106, my lord.
Where are the records, departmental records?
Correspondent 7 maybe? 6.
You are not prepared completely. Is that correct? Are you prepared to argue this matter?
My lord,
You are not
this is the
prepared.
only submission, my lord. If any appointment date is required, in that case, my lord, may allow me 1 day time only, my lord, for the date of
All right,
appointment
what
only.
is your case, Mr.?
Now, my lord, now I have taken my lordship now. So far the recommendation made by the APSC vis-a-vis the private respondent, my lord. Their recommendation was made against the PWD roads department, my lord. And if your lordship look into their seniority position in that list, my lord, that my lord will find I'll taking your lordship to that gradation
No,
list.
only point which will matter here is who joined the veterinary department on what date?
Yes,
Is there a list of dates on that?
I've said my 23/9, that is my date of appointment, my lord.
23/9 or 23/10?
My lord, 23/10, 1990.
1990.
1990.
And
1990.
and the private respondent is 4/4/1990.
Lordship.
Private respondent's date of appointment. in,
No,
veterinary
Recommendation was 23/3/1990, my lord. For the private respondent, my lord, may kindly turn to page number 93, sorry, my lord, 96, paragraph 4 of our affidavit, my lord. My lord, the recommended a public service commission by letter dated so and so dated 23/3/1990, my lord, with effect from the date of their appointment in the department, my lord. And my lord, they were appointed in animal husbandry and veterinary department in the year 85, 86, and 88 as per annexure A, my lord. Type copy is at page number 100, my lord.
Now, my
Yeah,
lord, they
temp-
have clarified there's 10 and paragraph 6, my lord. That what is the dispute here, my lord? Page 97 of their additional affidavit, my lord. That how they try to justify. They have not denied our allegation. But they
Mr.
say,
Chair.
since these people are continuing, so have regularized them. In oblivious of the recommendation, oblivious of their respective merit in the APSC select list, my lord. Now, as per APSC select list, if your lordship look into page 31 to 44, my lord, I'll just take your lordship. Their seniority in the PWD roads graduation merit list will find, my lord, respondent number 4 is 41. Respondent number 5 is 226. And respondent number 6 is 143. And I was 5 and 6. In the veterinary husbandry department, my lord. But by in the oblivious of all these, they have been regularized, my lord. Only on the ground that they are continuing. It is settled law, my lord. They have appeared for the selection process to regularize their service. And while you are regular, you can't, my lord, act in contrary to the, my lord, in order of merit in the list recommended by the APSC, my lord. There is 2 lists. My name appeared against the Animal Husbandry Veterinary Department. I was in 5 and 6. They have been recommended on PWD road. These 3 private respondents, their seniority is at, my lord, at 41, 226 and 143 respectively, my lord. Lordship will may kindly look into page 33, 38 and 36 of my writ petition, my lord.
Everything is jumbled up. So I'm having a serious propensity of posting the matter again after 4 weeks.
I'm sorry.
Why don't you present your case properly? What is the case? After hearing this, the only order will pass is list again after 4 weeks. Because we have to decide. You can say whatever you feel like. You have to. I'm not understanding your case, Mr. Ghosh. I'm so sorry. I've not understood anything. What are you saying? What is your contention? What is the systematically you have not argued the matter?
I said, my lord, I have been appointed again.
I'll come back in 5 minutes. If you can present it systematically, then I am willing to hear. Otherwise, let it be heard on some other day. This chaotically, I can't hear the matter. You have to place the case one by one, the relevant fact.
Because that have not enclosed, my lord. That have not enclosed, my lord. That was, I'm not.
When was the advertisement issued? Advertisement was issued when?
By my lord advertisement, my lord, paragraph 5, my lord, of my report.
Advertisement was paragraph 5. Okay. Then,
my lord, that is a statement, my lord, because advertisement I could not enclose. 1990s, my lord. I could not enclose.
So thereafter, what happened?
Thereafter, my lord, I was on 20 days, I said, my lord, 23 to 90. Both the petitioner 1 and 2 are appointed, my lord. Then, my lord, we appeared for a regular selection process in the APSC, my lord. Because that post have been regularized, that is 3F, my lord, under 3F, my lord, of the APSC limitation of function regulation, my lord. So it was a
Mr.
temporary.
Gupta, I'm not able to understand your case.
My lord, my initial appointment was a temporary under 3F of the Assam.
Where is that appointment? Where is it? Where is that appointment order? Page number?
My life, it did not enclose my lord appointment order, but my lord, thereafter I appeared for
I
the.
will not write a judgment unless the full facts are given.
My lord, thereafter I appeared for the selection, regular selection.
You want, look at only these 3 things and give me a judgment in my favor. That's what your case is. Only look at who is selected for which department and give me a judgment.
No, I am not
We will
saying
not
that.
do it like that.
Well, I said I
You
appointed
have to be given the full view of the facts.
23,390, my lord. I was appointed under 3F. Under the Assam Animal Husbandry and Veterinary Department.
23, 1990.
1990, my lord.
You are appointed under 3F.
3F, my lord.
All, both the writ petitioners.
both the writ petition.
All right. For how long?
Then, my lord, on 23 to 1990, I underwent, my lord, the regular selection process to APSC, my lord, because post has to be regularized.
This 23/3/1990, you were appointed.
Yes.
When did you join?
I joined on 23, my lord, on that day itself, my lord. Lordship will finally see.
Where is the statement?
No, Lordship will finally see that the official applied for the post and was selected and recommended for direct recruitment by the Assam Public under so and so dated in order of merit in the Animal Husbandry and Veterinary Department against the vacant 9 posts. Petitioner beg to state that, my lord, then paragraph 6, APSC 5 number letter, the response numbers to the recommended evidence reason. And it is an admitted fact, of course, my lord, private respondent 4 by 6, they are appointed earlier to me, my lord. That I've seen the gradation list, my lord. They are also under 3 of my lord, in the veterinary and animal husband department. So, my lord, accordingly, all of them have to appear for the regular selection process in the APSC, my lord. And that was took place in 23/10/90, select list was prepared, my lord, on the basis of merit. So, problems start from there, my lord. Because in 23/19 selection list, my lord, in APSC, Iowa petition number 1 and 2 were recommended in the Animal Husbandry and Veterinary Department, my lord. And the private respondent 4, 5, and 6, they were recommended in the PWD Roads Department, my lord, by the APSC. And as part the, my lord, the merit list, my position was, my lord, as I already said, 4, 5, and 6, my lord, of the list recommended for the Animal Husbandry and Veterinary Department, my lord. And so far the private respondent 4, 5, and 6, they have been recommended against the PWD Roads Department, and their, my lord, their position, merit position, the gradation list in the PWD Roads Department was 41, 226, and 143 respectively. 4, 5, and 6, my lord. That gradation, that select list I have been enclosed, my lord. Thereafter, my lord, they have been regularized in the service, my lord. And by process of regularization, a purported provisional gradation list was prepared, and they were placed in above us, my lord. So that was kept in high. That was not even published as per, my lord, the service order, my lord. There is no service rule as per given by a set of instruction, my lord, service order, my lord. So they have to circulate the provisional gradation list, they have to invite the objection, and then they have to, my lord, the final gradation list. Nothing has been done, my lord. And that has been admitted fact. And lordship will find, we came to know this position when, my lord, 2 of the officers of my cadre was promoted, my lord, under 4D of the same APSC limitation of function regulation of 90. They are also under 4D, not a regular promotion, but officiating promotion, my lord. Then we applied in RTI, under the RTI, my lord. Then under RTI, we received all this information, my lord, that their recommendation against their PWD roads, they are in that list, my lord. They were placed much below us in the order of merit. We are above them in the order of merit, but despite in oblivious of all that, my lord, they have been made senior to us, my lord. So actually, we have challenged that also, my lord, that then we asked the sought for an information when you have published, finalized the provisional gradation list, my lord. Then they replied that, my lord, the provisional gradation list was published in view of a decision of this honorable court, my lord. The earlier decision of the honorable court was that, my lord, that I should also brought to the notice of the lordship, is that, my lord, they have challenged that gradation list, my lord. Then the honorable court held that the gradation list was published 20 years back. And then, so that list will be finalized 20 years back, and therefore the writ petition is not maintainable, my lord. But after we received the information on RTI, we came to know, my lord, that is there on the record, that the gradation list was not finalized in 1990. It was published by virtue of the order of the court in 2014 only, my lord, not in 1990. So what I said, they may say we are bound by decision, but my respective submission subject to lordship is this: when there is a factual difference between the earlier decision and the present case, my lord, because issue is subject to the, my lord, they depend on the facts of each case, my lord. And a slight decision from this case and, my lord, the later case lordship may they hold a different view, my lord. So that is my one of my submission. There, my lord, when in 2014 we came to know that they are as per their letter that the gradation list was finalized in 2014, then we challenged it in 2017, my lord. That is the situation, my lord. This is the in a national, this is the case, my lord. So I said that we challenge the final gradation list, my lord, by virtue of this High Court order, my lord, and that, my lord, my lord, they are interseniority between the petitioner and the respondent number 4, 5, and 6, my lord. Now they have admitted that, yes, they have recommended against the PWD road and their seniority, what I submitted before your lordship, that is also not disputed. They said, my lord, since they have been appointed in the Animal Husbandry and Veterinary Department and continuing therein, so we have regularized them in the PWD, in Veterinary Department, my lord, instead of PWD Department, though they are recommended in the PWD Roads Department by the APSC, my lord. Now the question is this, my lord, how you deal with the seniority, my lord? Because seniority has been determined by the APSC, my lord, on the basis of merit. When all of us appeared in the selection process, how you have tempered with the seniority, my lord? My seniority is 5 and 6. Their seniority is 41, 126, and 143. So when you prepared in the gradation, you cannot, my lord, to ignore the seniority made by the, my lord, APSC, my lord. That is, my lord, in my submission. If I am able to make your lordship understand about this case, my lord. And I said 2 petitioners have already been returned, my lord. Out of the 3 private respondents, 2 has already been returned. Now 3 posts is lying vacant, my lord. Now the petitioner cannot be physically put to the post. Even my lord is, I'm just saying, only the, my lord, notional this thing can be considered, my lord. So this is my lord. It is up to them, my lord, considering everything, my lord. Because I can also ask for a mandamus that they should be promoted, my lord. After all, they have to consider all these things, my lord. This is my subject. But is I able to make a lordship?
You bring the record. Mr. Ghosh, you have not even argued your case. You have given your opinion.
No, no, my
hearing matter,
that is
you have
effects
to
of the
face
case.
the facts. Heard Mr. Bijay.
That
was
is
Learned
effects of
Counsel
the case,
petitioner. Also heard Ms. M.
So my
Kotak,
commissioner, they
Learned
cannot do
Standing
it, my
Counsel,
lord. When
Agriculture Department, Assam. After hearing the preliminary arguments of Learned Counsel for both the sides. Oh, I also do. Ms. P. Sharma, Learned Counsel is present on the respond numbers.
3, Lord.
Respond number 3, after hearing the preliminary arguments made by Learned Counsel for the contesting party, this court is of the opinion that the departmental records depicting the procedure adopted while regularizing the service of the petitioners as well as the private respondents would be necessary for deciding the controversy involved in this writ petition. As such, on the request of Ms. Kotoki, this matter is directed to the Ministry again after 2 weeks, so as to enable her to produce the departmental records. Also prepare a list of dates showing who was appointed when, who was regularized when. Have you understood?
My lord.
The record will be done.
My lord, I have some personal difficulty today, my lord. With the consent of other side, my lord. The matter may come up on
Consent, I cannot say, my lord, because this is a 2018 matter.
next week on
No,
Thursday.
no. This is a new trend which is coming. One side says that today I have a decide difficulty, do it on that day. Then the court has to fix the matter on that day. That is not, if he agrees, then it will go for 6 weeks.
My lord, I'm ready with it.
All right, then continue.
I have got some difficulty, my lord, along with the records, my lord.
We'll see if the difficulty is good enough to adjourn. We'll see. What can be done? Since morning, this is what is happening. Every case, nobody is prepared. Every case, there is a request to adjournment.
The records will be required, my lord. I will have to
We'll
go
see.
through
Let
that.
me see. The court may not require the variance.
Well,
What are these matters?
there was a common advertisement issued on 17/4/2012 by the Guwahati University. for filling up of
2012.
17/4/2012.
Advertisement for what?
This advertisement concerns one of several posts. Now, in this repetition 4271, we have 4 repetition, my lord. In 4271, the post concerns are, my lord, LDA assistant. There are 4 petitioners. LDA. And in 4437, my lord, 4434, 3 petitioners, my lord, facts are similar, my lord. 4755, 1 petitioner for literary assistant. And 4762, my lord, 3 petitioners for computer typist. Now, if your lordship finds page 16 is the advertisement, my lord, the applications were called.
You are referring to which rate petition?
My lord, the first one, 4271, 2018.
Page 16 is the advertisement.
Page 16 of the.
So serial number.
Serial
5
number
is-
5, there were 10 posts
Hmm.
which were advertised, my lord. And this was for a regular vacancy, my lord, to filling up the regular vacancy. Now,
Which are
person
the
to-
other posts? Which are the other posts?
my lord, the other
involved in this
post,
Batch of rate petition.
yes, in 4434 2018, that is serial number 3 literary assistant. Sorry, my lord. In 4434, it's accounts assistant, serial number 4, 5 posts. And the 3 petitioners are before your lordship.
Account assistant is in WPC.
WPC 4434 2018.
And junior literary assistant.
4434 is, my lord, account assistant. The post advertises 5 and 3 petitioners before your lordship.
And what about junior literary assistant?
Junior literary assistant is 4755 2018.
How many petitioners?
1 petitioner, my lord.
And item 5 is,
4762.
no, it is 4434, you said. Not
4434, yes, 4434, accounts assistant. 5 posts advertised, 3 petitioner before launch.
And which is the fourth petition about?
4th is, my lord, 4762.
That is about?
That is computer typist. 6 posts advertised, 3 before your lordship.
It is 4762.
4762. Well, this was to fill up the regular vacancy which has been advertised. The person to this advertisement, we participated in the recruitment process. We were called for the written examination. We cleared the written examination. Thereafter, we were called for the computer proficiency test. We cleared that. Before that, my lord, before issuing our appointment, we were asked to submit an undertaking that we'll accept the appointment as a contractual matter.
We accept the appointment
As contractual, but the advertisement was regular. My lord, we were assured that this initially will be appointed for a period of 1 year and subsequently will be regularized. We accepted the appointment. We were appointed as a contractual. We continued service and time to time it was extended. Now, from the same advertisement, my lord, some other posts which were advertised, which they have regularized their services. Those candidates have been regularized. We filed the writ petition. Now, the stand of the Guwahati University is that after the advertisement and before the appointment, the Guwahati University Act was amended and therefore they could not fill up the regular vacancy without the approval of the government. Now, your lordship will find their affidavit, my lord, specifically this stand, my lord. That is the only stand they have. The affidavit filed by the respondent number 1, 2, and 3.
Yes.
Para 5. May I read it, madam? With regard to the statement made in para 6 of the petition, your deponent begs to state that the posts mentioned in the advertisement were sanctioned posts. This, they accept that. Before appearing in the interview, the petitioner were requested to sign in an undertaking showing that they will be appointed on contractual basis, initially for 1 year. In this regard, it is to be mentioned herein that notification dated 30/05/2013 was received by the government of Assam. By the above orders of the governor, the university was compelled to maintain the teaching and non-teaching staff ratio. As per the government notification dated 30/05/2013, a new section, that is section 44, was inserted in the Guwahati University Act 1947 by amending the said Act of 1947, which is quoted herein below. The university shall establish and maintain the teaching and non-teaching staff ratio at 1:1.5 progressively. In order to establish teaching and non-teaching staff ratio, the university shall not appoint any non-teaching employee afresh against the sanctioned vacant post, and shall also not initiate re-employment of any retired person upon their retirement without taking prior approval of the state government. A bare perusal of the above, it is apparently clear that the Guwahati University established and maintained the teaching and non-teaching ratio of 1:1.5. In order to establish the teaching and non-teaching ratio, the university shall not appoint any non-teaching employee afresh against the sanctioned vacant post, and shall not initiate the re-employment of any retired persons upon their retirement without taking prior approval of the state government. It is further stated that as per section 44(2) of the Guwahati University Act, it provides that the university shall not take any decision or adopt any new rule or scheme which may involve further outflow of funds from the state exchequer. Therefore, due to the amendment of so and so, as stated herein above, the services of the petitioner could not be regularized, and they are continuing on contractual basis. And the para 10 mellow. Now the university says that they have sent a proposal to the state government for approval against the petitioners, and that is pending, and therefore they have not. Now, I'll take your lordship to my writ petition again.
Where have they stated that they have sent the proposal?
They have not said anything, my lord.
Then you are saying they have taken a stand.
They have taken a stand in paragraph number 10. When the proposal was sent, that has not been sent. The last line, my lord, the proposal for approval of the state government in this regard has been sent. After receiving approval from the government, the services of the petitioners would be regularized. Now, your lordship will kindly find for this petitioner, my lord, the university has taken a stand that because of the amendment of the act, they could not regularize the service of the petitioner. But for the persons who were appointed by the same advertisement, they have regularized on the basis of a decision taken by the executive committee of the university, on the ground that this advertisement is prior to the amendment, and therefore they are regularizing the service of these teachers, this non-teaching staff. And the office order, my lord, will find at page 33. These are the persons, my lord, who have been regularized.
They are recruited in the same selection process.
Same selection process. Page 33.
This is on the basis of executive council's decision.
Yes.
Where is the resolution of the executive
My
council?
lord, that record was called for by this honorable court, my lord. Several times this matter was heard, and this record has been called from the university.
So we'll dispose of the matter, asking the EC to take a decision.
In terms
Within-
of, my lord,
Within 6 weeks, in terms of,
my lord, the decision which has been taken earlier, my lord, the executive council,
and extend similar treatment to
My-
all those.
that will,
employees who have been-
that was,
My lord, may I submit, my lord? I take your lordship straight to paragraph 5, my lord. I'll be very short.
Paragraph
Paragraph
5
5 of the writ petition, my lord.
Yes.
The date, my lord. Page 6, paragraph 5. that accordingly thereafter calling letters were issued to the petitioners on 17/12/2016 for participating in the test of computer proficiency test scheduled on 30/12/2016 at Department of Computer Science and interview scheduled on 4/1/2016 at EC Chamber. So the date is of 2016. Now kindly turn to page 34, the appeal petition. Appeal petition by the petitioners. Page 34. Now kindly see the list, my lord. Page 34, down below, my lord. First one, LDA, date of written examination of 2013, result of written examination of 2013, date of cancellation of computer proficiency test 2013, date of computer proficiency test 2015, and date of interview 2016. So, my lord, it starts from 2013, but the date of interview was of 2016.
See, the law is very
But-
well settled.
but the
There is no
amend-
point unnecessarily wasting court's time. The date of advertisement will matter here, nothing else.
My lord, the Amendment Act came into force on 30th May 2013. That is very important, my lord, that cutoff date, 30th May 2013.
It will not have any application on
My
the
lord-
post to be filled up by the advertisement dated 17/4/2012.
My lord, we'll have to go by the amended portion, my lord.
Declare.
My lord, I beg to place before your lordship.
And what
one-
about the other employees who have been regularized? How was that done?
My lord, this was before that cutoff date, 30th May 2013. EC resolution was taken before 30th May 2013, in April 2013. So, my lord, these four judgments, my lord.
May I just correct that, my lord?
Let him.
Oh, yes, I just wanted to clarify that the appointments of these persons or was also after the amendment came into force.
No, my lord, it is not.
Yes, therefore,
My lord.
effect has been given from 22/10/2014.
First one, my lord, is Sun Bhagwati and others, similarly situated person. Paragraph 9 and 10, my lord, regarding that amended portion, my lord. Paragraph 9 and 10, the interpretation of this honorable court, my lord. May I read, my lord, paragraph 9 and 10, second page. 2018 3 GLT 758. The reasons given by the respondents in the view of this court stands in the way for the authorities in the higher education department for not taking a decision as to whether the approvals, it is important, my lord, whether the approvals are to be granted or not. If any such resolution of the meeting is required, it is for the respondent authorities to procure the same and take their decision thereof, but it cannot be accepted that the respondent authorities will not take any decision which they are statutorily required to do under section 44 of the Guwahati University Act 1947. 10. In such view of the matter, this writ petition is disposed of by directing the Commissioner and Secretary to the Government of Assam in the Higher Education Department to take a decision as regards grant of approval to the appointments of the petitioners on compassionate basis. So the interpretation of that amended section 44 is revolving around that approval of the government, my lord. Without approval of the government, that 1:1.5 ratio cannot be maintained, my lord. Now, my lord, this cut-off date aspect, my lord, one Muhammad Islam and others, Supreme Court judgment, recent judgment, my lord, 2022 9 SCC 67. I'll be very short, my lord, paragraph 17. 2022 9 SCC 67. Muhammad Islam and others versus Bihar State Electricity Board and others. Regarding that cut-off date, here, my lord, the 30th May 2013. Paragraph 17, my lord. I take your lordship straight to paragraph 17, my lord. If that be the position, may I read, my lord? The appellants in any event cannot contend that the scheme should be applicable from the very same date on which it had been made applicable to the state government employees when respondent 1 electricity board had the discretion to either adapt or not to adapt the scheme. When the board had decided to adapt in such event, it has also the discretion to alter the date of its applicability as against the date notified by the state government. Any judicial review on the date chosen for applicability would arise only if such choice of the date is demonstrated to be mala fide or with ulterior motive. In the instant case, the date chosen is the date on which the scheme was adopted, and the advantage or disadvantage thereof would befall on all employees across the board, depending on which size of the fence they are as on such date. So that cutoff date is 30th May 2013. So the Executive Council took the decision before that date. And regarding the aspects of the writ petitioners, it is after 30th May 2013, Milord. The interview was held in 2016. So that approval aspect must be there, Milord, from the state government. Now another case, Milord. Regarding loss.
You have not included the state government as a party here.
Here.
State of Assam is not a party.
Not a
State
party.
also
That,
not.
that was a technical defect, Milord. They should
So in the
have been.
second round, you make them party when you come back again.
Milord, Sanjay Kumar Dixit and others versus State of Uttar Pradesh and others, 2019-17 SEC 373, paragraph 16, Milord.
Paragraph.
Paragraph 16, the last 4-5 lines, Milord. It is in accordance with that Binapani Day case, Milord Jasmine. Last 5 lines, Milord. Next page 380, page number 380, Milord. Paragraph 16, last portion. It is settled law that there is no indefeasible right of appointment on the basis of inclusion in the select list. None of the candidates in whose favor relaxation was given have any right to claim appointment. However, we uphold the judgment of the High Court in favor of the candidates who submitted their certificates prior to so to do complete justice in the matter. So settled law that there is no indefeasible right for the Milord selected candidates, Milord. That Binapani Day case, Milord, 1967. Now, Milord, most importantly, that negative equality aspect, Milord. 2003-5 SCC 437. Paragraph 13, Milord. Since, Milord, Article 14 does not, Milord, indicate, Milord, that negative equality, Milord, it is only regarding positive equality, Milord. Paragraph 13 of that judgment, Milord. May I read, Milord? Paragraph 13, page 444, Milord. What remains now to be considered is the effect of permission granted to the 32 vessels, as highlighted by the Learned Counsel for the appellants, even if it is accepted that there was any improper permission that may render such permission vulnerable so far as the 32 vessels are concerned, but it cannot come to the aid of the respondents. It is not necessary to deal with that aspect because 2 wrongs do not make 1 right. A party cannot claim that since something wrong has been done in another case, direction should be given for doing another wrong. It would not be setting a wrong right, but would be perpetuating another wrong. In such matters, there is no discrimination involved. The concept of equal treatment, next page, Milord, on the logic of Article 14 of the Constitution of India, in short, the Constitution, cannot be pressed into service in such cases. What the concept of equal treatment presupposes is existence of similar legal foothold. It does not countenance repetition of wrong action to bring both wrongs on a par. Even if hypothetically it is accepted that a wrong has been committed in some other cases by introducing a concept of negative equality, the respondents cannot strengthen their case. They have to establish strength of their case on some other basis and not by claiming negative equality. So one
You are saying that
section,
the other employees were wrongly regularized.
Milord, I cannot say, Milord, they are wrongly regular, but
Where is
if,
the question of
if-
negative equality?
since, Milord, Article 14 has sought to be invoked, since one part of the employees, they have been regularized, so they should have been regularized. So that equality, Milord, they should have established their rights. Since it's that cutoff date, Milord, it is very important, Milord. From 30 May 2013, Milord, state government's approval must be required, Milord. So the other section of the employees, their interview and all aspects is over by, Milord, 30th May 2013. But their interviews were held in 2016, 3 years after the cutoff date, Milord.
So, my lord, there is no that arbitrary action on the part of the
They were appointed after 35/2013.
35 2013 on contractual basis. But the other section, my lord, they were regularized prior to that cut-off date, my lord. Since approval of the state government is not required. But as per section 44(1) of the Guwahati University Act 1947, my lord, it is required, and Sun Bhagavati is clear, my lord. Approval is must from the state government. And state government, since state government is not a party in this, my lord, writ petition. So, my lord, technically, my lord, it's not proper, my lord, to proceed with the writ proceeding. That is my submission.
One of the advertisement was issued in the 2012 and the computer test which held in November 2013. Even though after the amendment, they did not drop this recruitment process. They ought to have dropped the recruitment process. They went ahead with the recruitment process.
Mr. Kaushik,
Malad.
if you argue more, it will weaken your case.
Malad.
I think it is better you keep quiet.
Malad.
Huh?
I'll leave it.
The arguments you are making is only good enough for this court to write a judgment dismissing your case. So better you keep quiet.
I'll leave it to you.
Yes. What about the other vacancies? So there were
Similarly situated.
Malad,
10 posts of LDA. Only
there
three
were
peti-
10 posts of LDA.
Only 3 petitioners have come. What about the others?
Others, Malad, no, they have not approached this honorable court. And many of them, they have left also. When they were given extension and they were not regularized, many of them, because they thought that this contractual employment
So the contract is renewed every year.
every year, and they're still in service. They're still discharging their duties. There is no dispute to them. And there is and the vacancies are there. These vacancies have not been filled up.
Only one aspect, my lord, petitioner number 3. He has been terminated below. Since he has been involved with that APDCL scam. So petitioner number 3, Shashank Soikia, he has already been terminated.
Petitioner number 3 in which case?
My lord, the first case, my lord. Case number, my lord, item number 17. Riyadul Haq and 3 others. And against the termination order, he has, my lord, preferred a writ petition before this honorable court. This case is pending, my lord. Shashank Soikia, petitioner number 3.
Petition.
Still pending. Stay as vacating petition. Vacate one. Yes,
I've been told that the termination has been stayed by the honorable court.
but one vacating petition is.
Look, yes. I'm
One
not there in that
vacating petition is still there, my lord, and he has not been reinstated as yet.
All right, heard Mr. B. Kaushik, learned counsel appearing for writ petitioners in this batch of writ petitions. Also heard Mr. P.J. Pukar, learned standing counsel, Guwahati University, appearing for the respondents. Mr. The petitions are interrelated. On the factual aspects, and therefore are being taken up for disposal by this common order. The facts of these cases in a nutshell are that on (17/4/2012), the Guwahati University had issued advertisement notice number NTS/5/2012, inviting applications for filling up a number of posts in various categories, including one post of junior literary assistant -proof reader, 5 posts of accounts assistants, 10 posts of lower division assistant, and 6 posts of computer typist. The advertisement notice clearly mentioned the scale of pay applicable in case of each post. In response to the advertisement notice dated 17/4/2012, the writ petitioners had submitted their candidature for the respective posts. First up, after going through the selection process, the petitioners were selected for appointment, and accordingly, order of appointments were also issued in their favor. First up, however, contrary to the projection made in the advertisement notice, which had reflected that the recruitments would be made against vacant sanctioned posts, the petitioners were asked to give an undertaking accepting their initial appointment as contractual employees valid for a period of 1 year. First up, according to Mr. Kaushik, believing the assurance given by the university authorities to the effect that their services would be eventually regularized, the petitioners had given such undertakings, accepting the contractual appointment. First up, however, despite the lapse of they were appointed in 2016. Despite the lapse of more than 7 years since their date of appointments, the petitioners are still continuing as contractual appointments with annual renewal of their service, thereby causing serious prejudice to their rights and interests. First up, by referring to the materials available on record, more particularly where is that list of other candidates having been?
Page 34.
More particularly,
Page 34.
the
1/11/2006.
page 34.
Page 33. Office order.
More particularly, the office order dated 01/11/2016. Mr. Kaushik submits that a number of similarly situated employees who were appointed pursuant to the selection process initiated wide advertisement notice dated 17/4/2012 have since been regularized. Notwithstanding the same, the case of the petitioners have not been considered for regularization till today. As such, the petitioners have been compelled to approach this court by filing the instant writ petition. First up, a joint affidavit on behalf of the respondents, a joint affidavit sworn by the registrar, personnel department bracket establishment. Sworn by the registrar, Guwahati University has been filed on behalf of respondent numbers 1, 2, and 3. First up, the reason for not regularizing the services of the petitioners has been spelled out in para 5 of the affidavit, which is reproduced here and below for ready reference.
There are 5 and 8, Miller. 5 and 8.
First up, in paragraph 10 of the counter affidavit, it has been mentioned that due to the issuance of the government notification dated 30/5/2013, the services of the petitioners would not be regularized, although regularized full stop. However, the proposal seeking approval of the state government in this regard has been sent. First up, after receiving the approval of the government, the service of the petitioners would be regularized. First up. from a plain reading of the amendments made in the counter affidavit, it is apparent that the amendments carried out to section 44 of the Guwahati University Act, 1947, which was notified on 30/5/2013, has been shown as the only reason why the petitioners have not been regularly absorbed against the vacant sanction posts, in respect of which the advertisement notice was issued by the university authorities. First up. Mr. Phukan has strenuously argued that section 44 of that amended provision of section 44 of the Act of 1947, I got a Guwahati University in bracket for short act of 94, would be binding on the university. Therefore, binding on the university, since the process of selection, including computer test and interview of the writ petitioners, went up to the month of January 2016, by which time the amended provision of section 44 of the Act of 1947 was notified on 30/5/2013. The university authorities did not have the authority or jurisdiction to regularly appoint the petitioners, and that too without obtaining the approval of the government. First up, contending that
Sun Bhagavati, my lord, paragraph 9 and 10.
what is there in Sun Bhagavati? What has been decided?
My lord, that approval must be there, my lord, before regularly appointment, my lord.
Which line is that?
Paragraph 9 and 10, my lord. My lord, paragraph 7, my lord. On a reading of section 44 of the Guwahati University Act, it indicates that the legal duty is entrusted, paragraph 7, my lord, on the appropriate authority in the Government of Assam to consider as to whether the approval for such appointment is to be granted or it is not to be granted. A legal duty having been entrusted, the authorities in the state government cannot sit over the matter and refrain from taking a decision as to whether the approvals are required to be granted or not.
By referring to the decision of this court in the case of Sun Bhagavati and others versus Guwahati University and others, reported in 2018, bracket 3, bracket close GLT 758. Mr. Phukan submits that obtaining approval from the government is mandatory. First step. It is also the case of the Learned Standing Council for the university that
Regarding no indefeasible right, my lord, that Sanjay Kumar Dixit case, my lord.
there is no indivisible right of the petitioners to be appointed merely because they were selected, and assuming that the other candidates were regularized in violation of the provisions of amended Rule 44. There is no concept of negative equality
Under Article 14.
Full stop. In support of his above arguments, Mr. Phukan has placed reliance on the following decisions rendered by the Supreme Court. That was Sanjay Kumar Dixit versus State of UP. And next is Union of India and another versus International Trading Company and another. And the third is Muhammad Islam and others versus Bihar State Electricity Board and others. First up. I have considered the submissions made at the bar and have also gone through the materials available in record. At the very outset, it must be noticed herein that the writ petitioners in item 7, you write the case number, numbering 4 in total, had applied for the post of item 17, post of
In 17, my lord, post of lower division assistant.
lower divisional assistant. And they were contractually appointed in the said post pursuant to the selection process. Likewise, the 3 petitioners in item 18 had applied for the post of accounts assistants, comma, the 3 petitioners in item 20 for the post of computer typist and the sole petitioner in item 19 for the post of junior literary assistant cum proofreader. Full stop. Full stop. Although Mr. Pukon has submitted that the services of the petitioner number 3 in item 17 has since been terminated on the ground of alleged misconduct, this court is not concerned with the said aspect of the matter, since the order of termination appears to have been assailed by the said petitioner. Petitioner number 3, Shashanka Saikyar. Shashanka Saikyar. Appears to have been assailed by him in another writ petition pending before this court. First up, be that as it may, since the only ground taken by the university authorities in the counter affidavit for not regularly absorbing the writ petitioners herein is due to amendments carried out in section 44 of the Act of 1947 with effect from 35/2013. The core issue that would arise for consideration of this court in the present proceeding is as to whether such amendments to the Act would have retrospective application on a recruitment process which was initiated prior to amendment of the Act, that is on 17/4/2012. The answer to the said question has to be in the negative. First up, in the present case, as noted above, the recruitment process was initiated on 17/4/2012. First up, as such, the vacancies were in existence prior to the date of issuance of the advertisement notice. First up, moreover, the respondents have clearly stated in their affidavit that all the posts advertised on 17/4/2012 were sanctioned vacant posts. First up, if that be so, it is apparent that the recruitment drive was meant for filling up sanctioned vacant post on the basis of regular recruitment process. First up, therefore, the advertisement notice dated 17/4/2012 does not mention anywhere that the selected candidates will be engaged on contractual basis. First up, if that be so, the stand of the university authorities that the petitioners would only be absorbed on contractual basis due to amendments carried out to section 44 of the Act of 1947 with effect from 35/2013 appears to be wholly untenable in the eye of law and therefore stands rejected by this court. It is also to be noted herein that there is no dispute about the fact that a number of other similarly situated persons were regularized by the office order dated 01/11/2016. Although even those non-teaching staff were recruited on the basis of the same advertisement notice dated 17/4/2012. Full stop. In his attempt to create an intelligible differential in the matter, although Mr. Fukan has strenuously argued that the process of interview of those candidates were concluded prior to 30/5/2013, whereas the interview process of the petitioners continued beyond that date and until the month of January 2016. Such argument, I am afraid, such argument of Mr. Fukan cannot be countenanced by this court. Full stop. The process of conducting interview, stroke proficiency test, etc., is merely a part of the recruitment process, and same cannot confer any right, any special right on any of the selected candidates for being governed by a particular provision of the statute. Full stop. What would only matter in this case is this provision of the statute which was holding the field on the date on which the advertisement notice was issued. Moreover, even the beneficiaries of the office order dated 01/11/2016 appear to have been appointed after 30/5/2013, but without seeking any approval, but apparently without seeking any approval from the government of Assam.
Milord,
That-
may I, Milord, the EC resolution was taken on 29/4/2013. The EC resolution, Milord, the Executive Council resolution. And that
the
budget
only-
aspect is
only-
also there, Milord.
Only distinguishing feature being that the resolution of the Executive Council
Council.
in this case was taken on 29/4.
29/4/2013, prior to that cutoff date.
Full stop.
And that budget aspect is also there, Milord, complicated aspect, Milord, since Milord, budget is allotted by the state government and
Even-
they are not party.
Even if such argument is granted, even if such argument of the respondents is granted by this court, even then, for the reasons stated herein above, the decision, the date of decision of the EC in this case would not have any decisive bearing on the right of the selected candidates to be appointed. In the opinion of this court, would not have any decisive bearing on the question of rights of the employees of being appointed against the respective posts. Full stop. Once the authorities had issued an advertisement notice spelling out the qualification, number of vacancies and the pay scale, etc., applicable in respect thereof, the same would be binding on the respondents. Full stop. Merely because an amendment was carried out subsequently to a provision of the Act, putting a rider in the manner in which some of the vacancies were to be filled up, that by itself cannot denude the petitioners of their rights to be absorbed on regular basis against the sanctioned vacant posts in respect of which they had participated in the recruitment process. Even otherwise, since the statute permits engagement of the petitioners after obtaining the approval of the government, there was nothing stopping the university authorities from obtaining such approval and thereafter taking a decision in the matter of regular absorption of the petitioners, which exercise has evidently not been carried out in the present case. First of the decisions relied upon by Mr. Phukan on facts have been rendered, relied upon by Mr. Phukan on a close scrutiny, goes to show that those were rendered on completely different fact situation. First of even the judgment in the case of San Bhagavati and others, bracket Supra, does not lay down any proposition of law restricting the GU authorities from obtaining the approval of the government if the same is warranted. Full stop. However, such requirement of obtaining approval would arise only when there is a statutory provision mandating the same. Full stop. This court has already opined that the amended provision of Section 44 of the Act of 1947 would not have any bearing in the question of regular recruitment of the petitioners on the basis of the recruitment process initiated as per advertisement notice dated 17/4/2012. For the reasons stated herein above, this court is of the opinion that the writ petitions, all the writ petitions must succeed and are hereby allowed. The writ petitions are therefore disposed of with a direction upon the register of Guwahati University to process the case of the petitioners in the light of the observations made herein above, and thereafter take necessary steps for regular absorption of all the petitioners by issuing necessary office order. The aforesaid exercise be carried out and completed as expeditiously as possible, but not later than 8 weeks from the date of receipt of a certificate.
That approval aspect, approval aspect from the state
Read
government.
the judgment, you will see, we have said 44 is not applicable. No need of approval. 44, amended 44 will not be applicable here. So if before amendment, if approval is not required, now also it will not be required.
And since the executive council has taken the decision earlier, so executive council is.
So register is to process it. You will decide before whom it is to go. We don't need to say anything on that. The direction is to the register.
The executive council is the decision-making body, So,
So what you want the direction to be executive council?
The matter should be placed before the executive council.
The registered Guwahati University shall accordingly place the matter before the executive council of the university for taking appropriate decision in this case. In these matters.
Most obliged.
So is a division bench.
Adjournment like it.
Record produce করবেন তো?
Record আছে?
Record যদি কিছু time adjournment.
No.
Not praying for adjournment.
Adjournment. How many days? Adjournment for how long?
How long? Any day.
On the prayer of Miss
And that's all.
and Datta, this matter stands adjourned for 1 year. Mr. H. Sharma, learned additional senior government advocate Assam is present on behalf of the respondents. 1 year adjourned for
1 month.
1 month.
Lordship, here records are still awaited. We have written to them thrice so far, but
What is the matter, Mr. Sharma?
Service matter.
Records will be necessary.
Records, because they say, during the period where the inquiry was going on, I was, as per rules, my promotion has to be considered and that has to be kept in seal cover. They stated it, but nothing has been mentioned in the affidavit regarding that. And for that whole period, my lord, I have been denied promotion.
No, we'll get the records then next week.
Your lordship, 2 weeks time, your lordship.
No, why? This records from where?
It's a personal department, so this for only.
Personnel department is not moon. It's not, you don't need a Chandrayaan to go there.
No, your lordship, no.
Mr. D.T. Chalil, senior counsel is present on the petition. I1, on the request of Mr. D. Boral and appearing for the state respondents, these matters is directed to be listed again on 3rd August 2023. So as to enable the Planning Department Council to obtain the records. All right, yes. So there is a division bench in the second half.
Those division bench matters are actually the matters which relate to Provincialization Act, the challenge to the Provincialization Act. And they were ordered by the division bench one to be listed before a constitution. Today, madam, the matters have come up in all in jumble manner, showing everything which try to formulate it out, madam. They will try to break it down.
Very initial stage, no action has taken place as yet. They have not filed any affidavit. And it doesn't relate to any kind of challenge against any rules or action. My claim is that I fit in within the given scheme. Therefore, I think this needs to be segregated and hard separated. In
Acha, we have taken note of your submission.
Yes.
Let us understand this has been listed for the first time.
Yeah, I'm told this is for the first time before this.
Why these matters have been listed?
In some of these cases, I'm told that the rules or the provisions of the act has been requested. Okay, yes, that's how. And the registrar has tagged all these cases to you there.
We'll keep it in mind. Your
Yes.
request.
133. I'm obliged.
But here, my lord, what had happened is all the
You are there in
cases-
item 1.
My lord, I am there for the education department, my lord, the
In item 1.
item one, my lord, yes, item one, and in the others also I'll be representing the education department. Oh, I'm sorry, my lord, I'm.
Yes. Chaudhary, what is to be done?
Lordship, so far as my lordships had provided me a small indicator, I'll just place before your lordships 2 documents. Oh, come on. Are it us? Okay, I guess. Lordship, the paper books have been provided to us very late, so I could not file this thing as a matter of a report. Your lordship, I apologize for that. If your lordship will just give me 2 minutes of your lordship's valuable time. Now, the first document which I have provided, this is an overview of the harmonized guidelines of space standards. Now, this is a accepted norm, and this was of 2016. Thereafter, lordship, this entire document was compiled by Shishu Sarathi. Thereafter, this entire thing has also been substituted now by the other document which I have provided. This is otherwise a very voluminous 550 pages document. I have only placed the most relevant portion before your lordships of that particular document. Now, these two things are completely dealing with all infrastructural matters and how a building should be made accessible and what are the requirements for that. If your lordships will just take up the first booklet first, and if your lordships goes to the contents, the page of contents in that particular booklet,
Yes.
your lordships will find the headings: passenger alighting and drop-off points, then access to building, internal corridors and accessible routes, doors, handrails, grab bars, controls and operating mechanisms, drinking water, signages, curb ramps, stairs, lifts. These are all the different kinds of parameters which are required to be followed when a building is actually being constructed. Now, when we had visited Golaghat, I apologize, Your Lordship, I had indicated that although they have tried to make the building accessible by putting up a lift from the parking lot itself, the size of the lift is such that a wheelchair would not enter the lift. So the entire purpose of having an accessible building gets lost. And so therefore, this was a compilation which was made from the entire guidelines. This was a compilation which was required to be followed in the year 2016. This has now been further upgraded by the 2021 guidelines. And here your lordships will find that even for judicial buildings, there is a, if your lordships will see, 6, no? Page number 15 of this compilation, the pages are at the bottom. Serial number 6. There is a deal, they have dealt with judicial and legal buildings at 6.10. At the bottom, your lordships will find the pages, page 15.
You're referring to which
This one, page 15. And serial number 6, building typologies.
Yes.
6.10 is dealing with judicial and legal buildings. And thereafter that your lordship will find at the pages where I have annexed. Arey, kahan gaya? What did you do? 356 page ka hai. That's it. Yes. Did you seriously do this?
All right, 356 is perhaps not here.
Lordships, there were 2 pages which perhaps my learned friend has missed to this thing to annex before your lordships. That was the entire how the judicial building should be made. I'll just produce it. We have a soft copy of that. We'll produce it before your lordships. And these are the evaluating tables. So anytime that a building is otherwise the infrastructure is the blueprint is prepared, whether these things are there or not, these are the checklists which are required to be followed. And everything is in the signages of mm. 300 mm is normally 1 feet. And so therefore, as per the mm which has been declared in each of these tables, there are several tables which we have given to your lordships. And those tables are the ones which are talking about this is the entire checklist, your lordships, before your lordships. So this is what is required to be followed insofar as the accessibility part is concerned. This is all that will be required to be followed. Lordships, I may also point out that my learned friend Mr. H.K. Das is the one who's otherwise addressing your lordships in the other matters, but his name is not reflected in the cause list today. Perhaps he's missed the matter. I'm not aware. But the other aspect of the matter, he's the one, because he's the standing counsel Guwahati High Court. He's dealing with the other aspect of the matter, your lordships.
All right. Would you have any?
Actually, is concerned, I would like to file an additional affidavit, madam. There were some deficiencies, my lord. Some wall had to be completed and all that, my lord. Some housing has to be provided. My lord, instructions we have received, my lord, but we'll be filing it in a day or 2. This affidavit, up to date status.
Therefore,
I'm appearing on behalf of Mr. Anjan Kalita.
Mizoram.
Mizoram.
Will be Mizoram.
and
Receive my instruction, sometimes.
all right. Anybody from Assam? Nobody's.
Was filed on 29th of July. 22nd of July. It was filed.
22nd of July.
And so far as this booklet, etc., furnished by my learned friend is concerned, my lord. My first response will be like this, my lord. This possibly has been prepared in consultation or
Social welfare department.
No, true.
Document of social welfare department.
True.
They
Well,
only
my,
compile-
if your lordships take into consideration this aspect, well, this says that while constructing a building, and if it is court premises, then the guidelines which have been provided are to be followed. Now, this can be of some help when the construction starts. Now, a building which is already under constructed, then suddenly with these kind of changes can be brought in. This is number one. Secondly, my lord, all right, if this has been done, this has been prepared, then lordship may pass an order that in future when a building is constructed by the state government, then the state government will be in touch with the Ministry of Housing and Urban Affairs Department, Government of India, and they will find out the because this may have been prepared, there may be some changes also. To what extent this has been approved also, we don't know, my lord. They have prepared it, it's all right. So from the Ministry of Housing and Urban Affairs Department, they will collect the latest literature about the construction of building which they have, and based on that they will proceed.
So what we do is,
My lord.
now that there has been some change in the format here, let things percolate, because now only one repetition will be there.
Yes,
Then the amicus, learned amicus,
My-
Mr. Das, he is not appeared today.
possibly he's not
His
aware.
name
my
is
lord.
not reflected. Look, he's appearing as a standing counsel of the Guwahati High Court, Your Lordships, but his name is not reflected today.
And apart from that, please also examine
Yes.
the documents
My lord, my lord.
circulated.
Let
by-
all the state governments, my lord, have a copy of this. Let them have their own response.
Also,
Chaudhary, would you want any assistance from the registry for making copies of these documents?
Lordships, if your Lordships would want to peruse the entire document, then perhaps yes, I can provide the soft copy. And if your Lordships would want to go through the entire report, because this is a Government of India notification. It is not that we had done anything about it. This is a Government of India notification of the Ministry of Housing and Urban Affairs. So this has to be followed by everyone.
And this is by Sishu Sarati.
That one, that's a small compilation, Your Lordships. That's a small, the earlier document was also as voluminous as this, the 2016 document. So it was a very small compilation which Sishu Sarati made just for the assistance of people who are working in this sector. That is the only reason why I placed that small booklet before Your Lordships. Otherwise, that was also a voluminous 480 pages document. This one is a 500 something page document, Your Lordships, and therefore I had only produced the relevant portion where I have unfortunately forgotten to annex those two particular pages.
That's all right.
One more aspect, Your Lordships, there is this volume 5, Your Lordships. Volume 5 of the paper books which have been prepared by the registry. Therein, there is that guideline which I had apprised Your Lordships about. That is the NCMS baseline report. That is the National Court Management System baseline report. It's a report of justice of a committee of Justice Badr Duraiz Ahmed. And Your Lordships will find that at page 1178. That is actually the guideline which is required to be followed by any, because it is from the National Court Management System. This needs to be percolated to all the judicial buildings or judicial officers who are looking after the administration side of it. Page 1178, Annex to B is the report, Your Lordships, of volume 5.
Page
1178.
790.
ये registry ने दिया था ना मेरे को। कितना सारा दिया था सिर्फ?
The registry has given it to her, but not to us. Well.
I apologize.
How many paper books are there? How many volumes?
Lordship, there are several. There are about 10.
All right, then today let's not complicate matters further.
My-
Let the parties first get all the documents,
Lordships,
right?
perhaps, yes.
And then we'll take it up in second week of September. In the meantime,
Lordship, second week of September, some difficulty on my part. Either the first week of September, subject to your Lordship's convenience.
all right.
September.
So we'll have it on 30th of September then.
August, Your
August.
Lordship, 30, yes, Your Lordship, 30th of August.
30th of August.
Take
Oh, HK Das.
May I please your lordship? Lordship, in this matter, I am appearing on behalf of Mr. H.K. Das lordship. Due to non-record name lordship, his name does not reflect in the cause list lordship.
Miss R.S. Chaudhary, learned amicus curiae, has appeared in this case. So Mr. B. Majumdar, learned additional AG Assam, Mr. B. D. Goswami, learned additional AG State of Arunachal Pradesh, Mr. A. Kalita, learned additional AG State of Mizoram, and Miss M. Kechi, learned senior government advocate, Government of Nagaland, for their respective clients. In terms of our order dated 26/2023, the registry has rearranged the files and merged the matter with WPC number 5873/2006. The connected documents have been constituted into a number of volumes which are available in the record of this case. First of Miss R.S. Chaudhary submits that the copy of the volumes prepared by the registry containing the papers connected with this matter have been furnished to her. However, the learned additional AG stroke government advocate appearing for the 4 states have submitted that they are yet to receive the copy of the paper book prepared by the registry. Full stop. We also find that the name of Mr. H.K. Das, learned standing counsel, Guwahati High Court, is not reflected in the cost list, as a result of which he is not present before this court today. Full stop. This court has also taken note of the documents, stroke booklets circulated by Miss R.S. Chaudhary, being the harmonized guidelines and space standards for barrier-free built environment for persons with disability and elderly person prepared by Sishu Saroti, as well as the harmonized guidelines and standards for universal accessibility prepared by the Ministry of Housing and Urban Affairs, Government of India, which depicts, which lays down the standard design for carrying out constructions in buildings so as to make it disabled friendly. The response of the respective departmental council on the aforesaid guidelines with the perspective of incorporating the same in the featured designs of judicial court buildings, etc., would be necessary. The learned additional AG state of Arunachal Pradesh, additional AGs of state of Arunachal Pradesh and Mizoram, as well as learned senior government advocate Nagaland, have also prayed for some more time to seek updated instruction and place the same on record in the form of an affidavit. In view of the above and on the request of counsel for the parties, we direct this matter to be listed again on 30th of August 2023 as fixed items by reflecting the name of valid counsel for all the parties in the cause list. The registered administration of this court will also remain present when these matters are taken up. Accordingly, his name shall be reflected in the court list.
Deeply obliged. Lordships, would I be required to provide a soft copy of the entire document? Yes, Lordship, I'll give it to them. Obliged. Lordships. Reading that out. Very good. Oh, of course, no. Actually, can you be like?
For hearing item 2 to 77.
Matters are, matter has to be segregated. I mean, 38 to 42, these are old pension matter. We are, the petitioners, they want old pensions, benefit of old pension scheme.
Just 1 minute. These are old pension scheme.
Scheme 38 to 42. Similarly, other matters are there.
Then what is the other category?
Other category is, I think, provincialization.
My lord, in my case, my lord, some of the cases are pensionary benefit. The person who did not get the pension, but similarly situated have already been getting the pension. That is item number. Some more cases are coming, my lord, not coming, my lord. More cases are there. Item 78, my lord. 134, 135, 136, 137. I'll file, my lord, let governments can segregate it the all so that I can.
Why it has come up like this?
Yes, my lord.
Is for everybody. My lord, there was a challenge to the Provincialization Act of 2017. There was a big bunch, around 1990 cases. Thereafter, several other matters were being placed before the Honorable Chief Justice, which either orders passed by the learned single bench were appealed against, or there was some other challenge to the rules itself. Therefore, my lord, there was one order from the Honorable Chief Justice, from the division bench, that there should be a special bench which will deal with all matters of provincialization, whether it be a rule challenge or whether it be any benefit arising out of the act. So now that is how this list has been made by the registry. Some inputs from us, some registry has traced out. This will cover different subject matters, my lord.
Yes.
So what I was proposing is the cases where the rules are being challenged, we have already segregated out, we have a list. I will provide that list initially. There are certain writ appeals which are against the orders passed by the single judge. That I will again separate out separately because that has to be treated as an appeal. Other writ petitions which were before the learned single judge yet to be decided by learned single judge, but have been transferred before this division bench because they relate to the Provincialization Act. That, my lord, will form a separate category, each one having their own different cause of action. Finally, my lord, those matters where two groups of people, one who were regularized and one who were provincialized, had prayed for pension, but the matter was disposed of by a single order. Since one group, the provincialization matters were also included in the judgment, that group has also been laid before this honorable court. Now there we have to segregate out which matters provincialization pension is concerned and which matters are regularization pension. Although they'll be before the, they are all in appeal against the same judgment. So where the provincialization matters were concerned, only those would be before this honorable court. Regularization and pension would perhaps go before the regular bench. So that segregation would initially be important so that we can at least proceed on how to approach each of the matters. Even in the rule challenge cases, my lord, there are 6 categories or 5 categories. Those categories have been already divided.
Which rule has been challenged?
My lord, the Provincialization Act 2017 was different provisions have been challenged where, my lord, we have given a list. Registry and the respondents together we formulated a list where the challenges could be grouped, where the number of teachers being are provincialized, the qualifications required, the base school and the amalgamating school, or even the tutor and teacher differentiation. So the differentiation we have to make first, my lord. Then this matters can be taken up. Otherwise, my lord, it will be chaos for. We will also not be able, because some we have filed affidavits, some we have not filed affidavits.
All right, take down. Let us first segregate.
Yes.
The sheriff, otherwise it will be a chaos.
I said 138, not 38, 138 to 142. So all pensions.
So that's all right.
I'll make the segregation. We all will cooperate. We'll make the
Please
segregation.
listen to the order
Yes.
I'm
Yes,
dictating.
yes.
Then if you want any modification, we'll
Yes,
do it.
yes.
After the order is dictated, you want any changes, we'll do it. And
But
in the
my
beginning,
case is-
Mr. Mahanta had also.
My case is completely different and matter pertains to the appointment of president in the SMGC school. So matter.
All right, so
So
you
121.
please listen to the
Oh, that's-
order. After that, if you want anything to be changed, we will change it. We will change it right now, right? Let's first have the structure. So you take down. The learned counsel for the writ petitioners in this batch of petitions, stroke appeals, There are read appeals also in this?
Yes,
Appeals are also there.
Read appeal, let's read appeal.
Item number 135 onwards.
So 2 to 77.
135 to 149 and 153 to 155.
Batch of regulations have appeared and make their submissions. Mr. R. Majumdar, Learned Standing Council,
Department of School Education.
Department of School Education, as well as Mr. N. Bora.
In respect of I, read appeal number, my lord.
Oh, read appeal we are not taking.
Item number 155, appellants.
You are the only one for the respondents.
I'm the only one. And there'll be SSA, my lord.
And Mr.
Finance.
And Mr. P. Nayak, Learned
SSA,
SC Finance, are present on behalf of the official respondents. Full stop. All these writ petitions have been bunched together and listed before this court today on the basis of order dated, which is the order? Full order is. Bunched together and listed before this specially constituted division bench on the basis of specially constituted division bench. Full stop. However, however, during the course of arguments advanced by the parties, it transpires that the writ petitions deal with different subjects requiring different nature of adjudication, and therefore it may not be possible to dispose of all these writ petitions. This is about item 2 to 77, huh? All these writ petitions by a common order. In other words, it appears that these writ petitions, although pertaining to provincialization of services of school teachers, yet the projections and dimensions in a number of writ petitions are different from one another. Full stop. As such, unless these writ petitions are further subdivided on the basis of the subject matter of dispute as well as the reliefs paid for therein, it may not be possible for this court to embark upon an exercise, embark upon an adjudicatory exercise in the matter. Full stop. In view of the above, registry to examine the aforesaid aspect of the matter and group these cases on broad headings of different categories on the basis of inputs to be furnished by Mr. R. Majumdar, Learned Standing Council, School Education Department, Assam, within 10 days from today. Full stop. It would also be open for the registry to accept suggestion and inputs from Learned Council for the respective petitioners in this regard before finalizing the grouping or regrouping of cases within the broad headings. Full stop. Once the aforesaid exercise is carried out and completed, let all these matters be listed with appropriate subheadings before this court for hearing. Full stop. This is 2 to 77. On this, anybody wants to say?
There are other matters which have not been
On
listed
this,
today, my
do you want to say anything?
This one.
Similar matters are also pending.
pending, my lord.
Achha,
because
then
that
you
has
add
not
one
been
more
listed.
line.
That has-
Since it is submitted at the bar that many other similar matters pending before this court have not been listed today, the respective counsel for the petitioners are also granted liberty to furnish particulars of their pending cases which have not been listed today to the registry within 10 days from today, right? So anything else in this
No, my
particular
lord, this,
category?
this will cover the, only.
So 2 to 77 gone.
Along with the registry, my lord, a copy may also be given to me, otherwise it will be difficult for me to update the same.
The registry will give you. All right, now let us go to 78 to
when it's 78
Again, the
and
same.
134, then 135, 136, 7 and 143, all are related to pensionary benefit.
But this will also require a regrouping, my lord.
Yes, my lord.
And once the regrouping is done, those matters which relate to pension arising out of regularization, the challenge, those can be segregated out. They are not relating to provincialization, therefore will not relate to the special bench. But the same judgment also deals with provincialization.
Just 1 minute.
কিন্তু কৰি ল'ব লাগিছিল
আমাৰ মাজত কৰি ল'ব লাগিছিলে। আমি আগতে কৰি ল'ব লাগিছিলে গভৰ্ণমেণ্টৰ লগত। Excess 9, no.
Continue karo. So far as
Drop for.
insofar as item number 70 to 1.
78, 134, 135, 136, 137.
Is concerned.
My 155 different matter. Regarding my love in OBBs, my love, they are in short.
It is submitted at the bar. That these matters include details referred from the judgment of the learned single judge dealing with issues of entitlement of petitioners under the old pension scheme.
Yes.
And the new pension scheme, as well as the claim of school teachers under the OBB scheme. First up. Here also, an exercise of similar nature is therefore called for so as to segregate and regroup cases on the basis of subject matter of dispute as well as the relief paid for. As such, the registry could follow the same procedure for regrouping of cases coming under item number 78 to 155. After taking inputs from the learned departmental council, first up, the learned council for the appellant stroke petitioners would also be at liberty to furnish necessary inputs to the registry as regards any matter pertaining to these petitions, the petitions, including the particulars of any matter connected with this series, which has not been listed today, though pending before this court. So let the same exercise.
Yes. Well, regarding 151, this is a case of non-payment of salaries.
So you give the inputs to the registry.
After provincialization. Okay, yes, ma'am.
Give the inputs to the registry, then they will themselves segregate it.
Yes, ma'am. I'll be blessed.
Needless to say, after receiving the inputs from the learned counsel for the parties and on examination of the records, if it transpires that any matter listed today in the above series is not required to be dealt with by the special division bench for reasons to be recorded in writing, those matters be segregated and listed before the appropriate bench.
I'll be blessed.
Item number 153, your lordship.
যেতিয়ালৈকে segregation টো নহয় তেতিয়ালৈকে এইটো কৰিব।
Interim order maybe can continue. 107 minute interim order is there. 107 sign interim order passed. Any interim order, any other matter? Interim orders, if any, passed in the respective petitions continue until further orders. All right.
This.